Yes.
Yes, Lord.
But the matter of SC category candidates termination of this certificate. The uncle who was against who got the certificate in 1994 when OBC concept came into 2011.
So, I cannot add any further upgraded matter. No, let me hear out some upgrade matter. 77 upgrade matters.
Upgraded matter I am praying for. I am praying
not now. Not
I will be terminated from my salary.
Yes.
I am a defense employee.
I cannot add any further, but let me hear out some matters. Upgrade. Yes. Come back on Monday. These mentions. Please come back on Monday.
Top has been closed.
Yes.
On a pretend that I have not made.
Let me call on the list. Yes. Come back on Monday, please. All.
I mentioned in the letter by letter. I
No, don't.
70 but 70 what I mentioned.
I won't take up any further mentioning. Let me take up some of the upgrade.
Gone down to 70.
Please call on the list.
45.
Accordingly, WPA 27117 of 2023 and WPA 27120 of 2023 are dismissed on contest without any orders to cause. Affirming the order of the appellate tribunal, directing the petitioners to deposit the principal amounts payable to the allotee to the tune of rupees 44,08,600 and 11,700, respectively, along with interest. Such amounts shall be deposited by the petitioners in connection with each of the appeals, which are subject matters of challenge of the two petitions, including the interest component, latest by January 10, 2024. In default, concerned appeals shall stand automatically dismissed. Next call. Which will be the What is, why is it happening for intervention?
From the intervention of the DAP or the national stall,
Achha.
villagers were creating problem. Lordship was used to direct my arrangement. Yes, he was to take the update.
So then what is your instruction? There's been resolved?
Pass the order.
I will post it.
I already put that order and record. I was having this supplemented works and money that only by the mark 2 things I have been praying for your lordship.
What is the resolution reached by the DA?
The last page of my
What is the resolution? It will remain there.
Yes, no. Objection of the village is unfounded. So your objection is outmutted. And the direction is to the local authority to carry on with the
Right.
on the land, do not impede.
Yes.
And Malato, what happens, Malato? Only I pray before your lordship.
Yes, Mr. Dev.
This protection in respect of the that your lordship knows. But I haven't been the one. Request
A supplementary affidavit is filed today, which is kept on record, which shall be transpires from the report filed by the respondent authorities that the district magistrate, that after the district magistrate apostrophe's intervention, the matter has been resolved to the extent that the villagers' objection has been found unfounded. The work, accordingly shall be carried on in the on the property donated by the petitioner. Next para. Learned counsel for the petitioner apprehends resistance by the villagers and seeks police help. Next para. However, since the matter is in the hands of the authorities, it is expected that in the event any resistance is faced, the authorities shall take adequate police help to implement the resolution reached by the intervention of the district minister. With the above observations, WPA 26324 of 2023 is disposed of without any orders to solve. No, that is beyond the scope. That is there. You don't have any cause of action for that. That's not an individual cause of action.
I think 4.
When does it expire?
December 20.
Wait. The interim order granted earlier is extended till February 29, 2024 or until further, whichever is until further order, whichever is earlier. The matter shall be listed for hearing in the monthly list of January.
Then 5 to 6.
Who is appealing for the petitioner? Let me take a 5 first. Yes. So these are separate matters, Mr.
Item number 5 is By differing division.
These are obviously separate matters. 5 has been referred because this issue is involved. That is only for the purpose of deciding that issue.
Yes.
And 6 and 7 are different, obviously.
5 not 6 and 7 would depend upon what's the root take your option takes in 5.
Yes. Maintainability, on
Only
maintainability.
the issue. Whether the decisions are maintainable or
Yes.
in respect of matters connected with election. Once the process starts,
Yes.
then it will
Now, you are appealing for whom? With Mr. Dotto. Who is appealing for the respondent in 5? Because they have to make their arguments also.
But we have respondents in 5.
Acha, well.
No, I'm sorry. Respondent in repetition, but appellate in answer.
So, very well. Let us file. Yes. You had preferred the appeal,
Yes,
obviously.
I have preferred the appeal. So the single judge blood had interfered with the decision regarding the nomination.
Is the respondent present here? I don't think so. What is the urgency, Mr. Doctor?
To be honest, I
Really not.
they,
No, 6-7, yes. 6-7, what is your urgency? You are for the petitioner. Suppose the difficulty is, it depends on the resolution of 5. The decision I take on 5. It has been referred. So, can you please give a notice? Who is Mr. Doctor? Can you please ask your junior to give a notice? Notice in 5. I mean, to the petition in 5. So that unless they decide that, suppose I cannot take up your matter. They are not here today.
But one thing where I would
Yes.
intimate your worship, but in under clause 36
Yes.
of the latest statement, the division bench or the bench differs
Yes.
in equal numbers, then the point is to be formulated and then refer to a third.
It has not been formulated.
It is not.
So, in the order,
But it is happened that one of the honorable judges have held that in exceptional circumstances, the petition is maintainable, and the other honorable judge has held that the risks are not.
no, in the order itself, no reference is recorded.
So that's it.
Reference is only by virtue of allocation by the.
The administrative order.
I'll just check up, please. The administrative order only says matter was listed on 19th May before the division bench of such and such for pronouncement of judgment, wherein Honorable Chief Justice has dismissed the appeal, whereas Justice Hiranmaya Bhattacharya has arrived at a different conclusion and disposed of the appeal. Under such circumstances, where a difference of opinion has come up between the two honorable judges, matter is most humbly placed before your lordship. This was the lay note, and the honorable Chief Justice said, "Be placed before me." So, the limited scope is that the Chief Justice said that had dismissed the appeal, apparently is not maintainable. Justice Bhattacharya came to a different conclusion. So it has to be on the maintainability of the writ petition or appeal. Writ. So then I'll have to hear there.
In addition to that, my petition that this question directly have hearing on my.
Yes.
And in addition to that, the data comes in fact, Dentist Stat 1948. This has been repeated.
No, there must be other grounds.
Other grounds.
But if the division is not maintainable at this stage, then
Yes.
we cannot.
No. Is it possible for my to take up the matter next week? Because otherwise I will.
No, I think I'll take it up this week only.
This week we are the last. Oh, acha.
Mr. Bose is there, Mr. Datta. You should not come in between. So if you want Mr. Bose, I can fix it. Wednesday, that's fine.
Any day except
I can keep it on Wednesday then, as a top matter also.
I can know the 6 months.
If Mr. Bose condescends.
My other source. So it is very fishy thing for
Item 5 after order. None appears for the respondents in the appeal. The matter has been referred to this court in view of a difference of opinion between the division bench in the said appeal. Full stop. Yes.
Sorry for interruption. Just say I don't know that on
Yes.
the matter from which the appeal arises at the interim stage your lordship had. But I don't think in my side there can be any.
No, our Chief Justice's view is that even if there is a difference of opinion, if a new bench is constituted, the persons who differ, one of them may be there. And I am a part of one of such benches, so I took the point before the Chief Justice. But if that be so, then the principle applies here.
Just inform, so that after hearing somebody.
No, definitely. Accordingly, let the matter stand adjourned till Wednesday, Mr. Push, till December 20, 2023, when it will be listed at the top. Push-up at 6 or 7 order record হবে. Since the adjudication of this matter is directly connected with the issue which has been sent on reference to this court in connection with MAT 411 of 2023, comma, let these matters be listed along with the said appeal on reference and reference on December 20, 2023. 6 and 7 will appeal along with that in this order.
Interlinked with some.
Please, sir. Yes. Of the central government. Oh, that, yes. Why? Why, sorry? Oh, Brucella vaccine, right?
বল সব নিয়ে যাবে পুরো ফাইল দুটো
বিপদ
ব্যাগ
আছে।
নিয়ে ওখানে রাখ।
ওকে দেখতে পাবো ওখানে চলে
হ্যাঁ
আসছে
পিটিশন গুলো ওখানে রাখ, শতাব্দী থাকবে তো, শতাব্দীকে যদি লাগে সাজিয়ে রাখ।
করছে কি অ্যাপিয়ার করছে নাকি
আমি তো নিজেরা কথা বলছি,
নিজের কথা বলছে আমি শুনতে পাবো কেন সেটা বন্ধ করে রাখতে হবে
বন্ধ ছিল
তাহলে লিংক দিও না
লিঙ্ক তো মানে পাবলিক
তাহলে মিউট করে রাখো
করে দিচ্ছি।
নিজেরা কথা বলতেই পারে নিজেরা কথা গালাগালও দিতে পারে সেটা শোনা না Yes, what is the order? Is it just Brucella vaccine? You are not paid during the the effect has been given retrospectively. That is the condition of the state also. I mean, because they are not paid. Yes, what is yeah. Yes, Mr. Dil.
They were paid, but paid if they are revised regulation.
I have put that in my order on the yes, because you said that. Yes. Yes.
Which is the operational guideline.
Right. Give copies to them also, otherwise they will. What does it say? Show me the relevant portion.
Comes to the page 15 of the operational guideline.
You have Mr. Basu, aren't you? Yes, Mr. Basu, page 15.
Page
15. Yes.
Point number 5.1.
Yes.
It was previous, the last point.
Right.
It was previously providing remuneration to vaccination which should be less than ₹3.
Should not be less than. Yes.
Vaccination due and ₹2.5 per annum for year taken. But that was previous one of the program getting before in the year of 2019. And this is the first time when the revised rate was that document are already placed on the next the party location. That is effective from 16th of February 2023. That is the revised rate where the remuneration of the vaccinated that was rather
Increased.
instead of that was increased by.
All right. It was not 12 and 13 at any point of time, according to
It was not might be it was stated in something but the central government is only to the effect that was revised in the 16th February 2023 and that comes to for the vaccination and crucial 5.
Now, have you seen the documents annexed by them and in the report also of the state?
Yes, it's right. But it is just received the document.
And now, today you cannot say just receive. You have got one day. Yes, Mr. Ghosh, your report probably should. What was the page number?
Your lordship kindly comes to page 11 of my report.
11.
Page 11. Your the activity chart. 1, 2, 3, 4, 5.
Yes.
brucella vaccination,
And this was published by the government of India.
mine,
Right.
rupees 12,
And 13. Oh, we are covered by 12.
Miller.
Right.
Data updating 2. Now your lordship kindly comes to page 41 of my report.
Yes, 41.
Miller, this is our approach for approval of funds for the financial year 2002. Miller, that 12 plus 2 was allotted for the year 2021. It's written there. For 2022 and 23, our approach was made, which is in page 41. Miller, in the bottom, which is also to bring to your kind notice that payment of remuneration for vaccination program phase 3 and FMD vaccination program will not be possible due to paucity of fund. Miller, lordship kindly comes to next page,
Yes.
approval of funds. Page 43, Miller. My lord, page 43.
Yes.
Miller, NADCP, brucellosis.
Yes.
1, 2, 3, 4 schedule remuneration vaccination that was reduced to this 4. This was done for the financial year. Lordship kindly comes back to page 42. The top subject administrative approval under areas DCP scheme for the financial year 2022-23. Dear your lordship kindly comes to page 47. Page 47.
Yes.
This is for the financial year 2023-24. Here, that amount of rupees 4 was increased to rupees 5. Your lordship kindly comes to the last.
Yes.
Vaccination
This
of
was also placed by your learned for the.
And your lordship kindly comes to the next page. This notice was issued by us, where in fact we have for the phase
22-23. The subsequent phase.
No, there are for the phase 3 and 4. Instead of paying at the rate of rupees 4, we have paid at the rate of rupees 5.
Which was the phase? Which was the phase?
Phase 3 and phase 4.
No, they worked during which phase? Their
Phase
agreement phase.
Phase 3 was conducted.
2021 was phase 3.
But phase 3 was conducted during July and August 2022. Phase 3 was conducted during July 2022. Your lordship kindly comes back to page.
What was the exact period during which phase 3 operated?
The phase 3 was operated during July and August 2022. Now your lordship kindly comes back to page 42.
But page 11 says it will be effective from 2nd September 2020.
Page 11 speaks about 2021, page 2.
No. I am asking which period are the petitioners agreed? Which is during 2021.
2022. July and August 2022, phase 3 was.
What is your period for which you are asking? What is the period for which you are asking?
For phase 3.
What is the year?
That is 2022. Now your lordship kindly comes to page 42 once again.
42, yes.
Below, this data has been served upon us on 22nd of September 2022 for the financial year 2022-2023.
Yes.
The financial year of 2022 starts from April 2022 ends at March 2023. Now, my lord, by this approval, the previous amount of rupees 14 was reduced to rupees 4. And my lord, since we have received it on September and phase 3 vaccination was conducted during the month of July and August, we were compelled to reduce the rate in terms of the approval that we have received.
Let us come to page 42 once.
Right.
There are certain allegations against you also apparently.
Right.
One says number 1, the administrative approval is subject to the following. A says no release is being made as of now, as 75% utilization of previously released funds is yet to be completed. So if you have not utilized 75% of the previously released funds,
these issues were settled subsequently further released.
funds were released. And we have received the funds in terms of page 43, 412223. And thereafter 412324, this rupees 4 was increased to rupees 5. And for phase 2 and phase 3 and 4. Phase 3 was contracted during the month of July and August 2022, and phase 4 was contracted in the month of January 23. But for phase 3 and for phase 4, since the amount of rupees 4 was increased to 5, we have paid them in terms of rupees 5, being the latest approval. This is my submission.
Yes, what is your answer to this? Page 11 of the report of the state. Let me pass my order now. Yes.
And we are only the implementing authority. We have no role to increase or decrease.
Very well. Very well. The petitioners worked under a scheme, which inter alia incorporated Brucella, BRUCELLA, vaccination, which was carried out by the petitioners. The said scheme was to be funded by the central government and operated under the aegis of the AEGIS, of the state government. It is contended that although the petitioners duly worked under the said scheme and the approved remuneration per animal during the relevant period, that is the year 2022, was rupees 12 for the state of West Bengal, the petitioners were not paid at such rate. Next para, Learned Counsel for the state places reliance on the report submitted by the Chief Executive Officer, Paschim Bongo Go-Sampad Bikash সংস্থা, and argues that a decision was taken in the minutes of the 6th meeting of the National Steering Committee of Central Sector Scheme National Animal Disease Control Program that for the relevant period starting from September 2, 2021, the approved remuneration per animal with regard to states like West Bengal for Brucella vaccination was to be rupees 12. Subsequently, by a communication dated September 22, 2022, in principle administrative approval under the LHDCP scheme for the financial year 2022-2023 was sent to the state. It is, however, pointed out that the said approval pertained to a period covering phase 4, that is subsequent to the period during which the petitioners worked. It is contended that due to the union withholding the due funds for payment, the state is not being able to remunerate the petitioners and other similarly placed workers under the said scheme of animal vaccination. Next para. Learned Counsel for the Union of India seeks to place reliance on an order dated February 22, 2023, issued by the Government of India through the Ministry of Fisheries, Animal Husbandry and Dairying, DAIRYING. The said order stipulates the revised rate of remuneration per animal for Brucella vaccination to be rupees 5. It is indicated in the same that the revised rates of remuneration will be applicable with effect from February 16, 2023. Learned Counsel also hands up previous operational guidelines which indicates that remuneration to vaccinators would not be less than rupees 3 per vaccination dose and rupees 2.5 per animal for year tagging, including animal data entry. It is thus submitted that the remuneration was increased per animal to rupees 5 and the union is not responsible for funding previous remunerations at higher rates. Next para. A bare perusal at the operational guidelines handed over by Learned Council for the Union of India indicates that the same does not pertain specifically to Brucella vaccine. Full-stop. Moreover, the same is merely an operational guideline and does not fix the remuneration as such. Full-stop. Next para. Insofar as the order dated February 22, 2023 is concerned, a copy of which has been handed over both by the Union of India and the state, the revised rates of remuneration as per the said rates would be applicable with effect from February 16, 2023, which is subsequent to the period for which the petitioners worked, that is July and August 2022 for phase III. Full-stop. Next para. Rather, the minutes of the sixth meeting of the National Steering Committee, comprised of all stakeholders, including at the national and the state level, dated September 6, 2021, clearly indicates that the approved remuneration per animal for states like West Bengal for Brucella vaccination was ₹12. Full-stop. Next para. The same was to take effect even as per the said minutes from September 2, 2021 and thus covered the period before the order dated February 2, 2023 came, the latter being operative only from February 16, 2023. Full-stop. Hence, during the relevant period when the petitioners worked, that is in the year 2022, the prevalent rate, even as per the National Steering Committee, also comprised of the stakeholders of the Union of India, was ₹12 per animal. Full-stop. Thus, there cannot be any ground on which the funds for remunerating the petitioners and other similarly placed workers under the animal vaccination scheme to be withheld by the Union of India. Full-stop. In such view of the matter, WPA 20153 of 2023 is allowed, directing the respondent numbers 7 and 8 to disburse due funds to it has to be paid. You will pay. Chief Executive Officer will pay. It will be given to whom? Who will pay to them?
You will pay a guidance. Chief Executive Officer.
To disburse to the respondent number 5, that is the Chief Executive Officer, the Pushchimbongo Go Sampad Vikas সংস্থা, the funds for yes, and specified the funds for the period covered by phase III of the said scheme, that is during the months of July and August 2022, at the rate of ₹12 per animal. Full-stop. Such disbursal shall be made as expeditiously as possible, positively by January 31, 2024. Full-stop. The Chief Executive Officer, that is respondent number 5, shall immediately thereafter, disburse such funds to the petitioners and other workers who worked under the scheme for Brucella vaccination of animals at the rate of ₹12 per animal, positively within February 29, 2024. Full-stop. No rest to process.
One more point, can we make it clear that any RTI worker who is refusing to undertake a Brucella vaccination shall not be compelled to do so by the state?
That we have also taken out.
They may make an effect all the court.
That is beyond the.
All right, without partial never and we have never compelled anyone.
They are compelling whom?
Yes, they are compelling to do so because they are refusing court to give me any work of artificial insemination unless they also agree to Brucella vaccination. Madam, the point is, Brucella is a dangerous vaccine to handle, and at this reduced state, none of the workers want to continue with the Brucella vaccination.
So how can they compel you?
They are complaining because they
Don't work.
They are taking away a livelihood because they tell the vaccination. It is a dangerous vaccination.
What is your prayer to that effect?
That part has been dealt with by us in the 10 of my. Even 11. Thanks, my other 25. Paragraph 10, 11.
First up, it is further clarified that the respondent number 3 that the respondent numbers 1 to 6 shall not compel the petitioners or other artificial insemination workers to mandatorily participate in brucella vaccination as a precondition of being allotted work under the vaccination scheme otherwise. Yes.
These were evidence were not exchanged, not allegations.
Architect together, since evidence were not directed, it is deemed that none of the allegations that made in the written petition are admitted by any of the respondents. Yes. Yes, Mr. Chatterjee.
Professor, but they did not supply information. Therefore, I filed an appeal which has not been disposed of. Yes, it is the petitioner was impaired as lawyer for special court of Storabo.
Which respondent is the appellate authority, Mr. Chatterjee? Which respondent is the appellate authority?
Appellate authority. Is 31. State information of case 31. State information commission, newspaper information commission, Khatwar complex 11A picture street, case 31.
Which respondent is to be directed?
Respondent number. State information.
You will give this answer? Yes, you may.
Respondent.
My largest
Respondent 3 months.
applying it right.
Respondent 3 months.
Right authority India
Respondent number 3.
teacher and a firm. He has applied the assistant office information, no the internal office, no. He is our internal handbook. You should know this.
So I am suspicious. He has not paid my.
This is not that.
They are not paid.
Designated authority already approach the designated authority.
For what? The payment of his fees.
No, but he has
Sought for information. What is the information sought by?
regarding fee.
I'm coming over. At my last 60-year-old office, kindly come and
Yes.
I submitted my professional duties to the department 2016 to 2018, amounting to ₹9,15,000. Thereafter, I will receive next page, whether any circular issue, director regarding payment of fees in respect of the learned advocate Excel calculation 2013 issued by the PR to the director HRT 19 to 2019, whether bill submitted by me from January 24 to May 25 and another bill since June 25 to May 26 submitted by me. Your department has been paid by your department on the basis of the
So this was not given by the first authority.
No, not given. There are like
Refused. Inaction.
Inaction. Thereafter, appeal also
Is kept pending. Kept pending.
kept pending.
Mr. Bole,
Whole issue.
why do you say the assistant public information officer is not the right person?
Designated authority is not the senior manager, human resource and administration, he is the prescribed authority under the act.
There is no application before. This is number one. The number two is.
Bahadur, why should he is living in Nadia and worked in that district?
zone. Our zone is.
State
Separate zone. Each of
Chief
it.
Information Officer,
The Nokia
for number 3,
under Governor. General office is.
But then what is the function of this assistant public information officer?
No, no, there is no designation of that. It's a wrong designation. And that is what we learn. The law is kind of, since he is also an advocate and embarrassing situation, well, kindly have a look to these two. I should
Give him
not.
a copy, otherwise.
Yeah, this is my instruction.
Let him also be embarrassed. Why should I alone be embarrassed?
Not instructions. Isn't it? Because abrupt bill has raised certain queries as well. Otherwise, we will be. I'm very sorry to bother that. Nothing.
That relates to the dispute. Why are you going about in a roundabout way? Why didn't you directly place your bills along with whatever documents are required?
here,
Better will be.
where is this?
You are going on asking information and then
Signature of the presiding officer. In the bill.
have you raised the bill before the appropriate?
Yes.
No, they say you have time to time placed your bills to the with the office of the RM Nadia region.
And not our system is
Yeah.
a
It has to
communication
be placed before the nodal officer. Please see before the nodal officer.
along with the communication. What has happened?
The grievance of the petitioner, who is an advocate who had apparently worked for the WBACTCL, is that the petitioner sought information regarding clearance of his bills, whose no information having been given, the petitioner approached the respondent number 3 with an appeal under the Right to Information Act, which has been kept pending. Who's the next para? Learned counsel for the WBACTCL submits that the appropriate officer before whom the information was to be asked was not the assistant public information officer who was approached by the petitioner, but the senior manager, human resources and administrative officer, Bahadur, who is entrusted with the said power. Bahadur zone, who is entrusted with the said power. Next para, it is further contended that in respect of the bills, the petitioner had placed the bills from time to time at the office of the RM, Nadia region, whereas the appropriate authority was the nodal officer or any other official of WBSETCL. Be that as it may, since the petitioner's present grievance pertains to information not being furnished, and an appeal is already pending, the WPA 20683 of 2022 is disposed of by directing respondent number 3, the State Chief Information Commission, West Bengal, Commissioner West Bengal, to decide the appeal of the petitioner as expeditiously as possible, preferably within January 31, 2024. It is further made clear that nothing in this order shall preclude the petitioner from approaching before the senior manager, human resources and administrative officer, Bahadur, with appropriate information without prejudice to his rights in the appeal, and as well as to approach the appropriate nodal officer or any other official of the WBACTCL with his bills for work done by him, appending therewith appropriate documents to substantiate his claims. If such approaches are made, the above mentioned authorities shall deal with such approach of the petitioner independently and irrespective of the decision arrived at by the appellate authority, that is respondent number 3 above. So all opportunities given, Mr. Cole has clearly indicated. Please ask for deposit your bills with appropriate papers before the appeal.
Bill will be clear.
Your information will not be necessary. Ask Mr. Cole whether WBSCL disburses bills properly. He will be the best person.
Actually, in your system, since it's pretty ideal this matter.
Mr. Cole, please just help Mr. Chatterjee slide so that. But I can very well appreciate, Mr. Chatterjee, the quality of your client's service given to WBC. If he does not know where to place the bills, He's not entitled to the amount.
He's our content advocate, he has to. Then you have to say.
Anyway, let us come. Good. Next one. 10. State. Yes, what is the matter? Section 14.
Section 14 is still pending.
Service on private. Yes. Yes.
They are taking that as all the cases are pending, lordship, they could not pass the order. The report of second page of the report. Lordship.
All the cases are.
Cases are pending, lordship, and second. So due to pendency of all those cases, this office could not pass any order on the section 14 of the service.
No, these appeals, how are these related with his function? How are these appeals, these matters related with his section 4?
They are sending this report.
What is the meaning of this report? It is pertinent to mention is that 4 cases under section 17.
And in the writ petition, lordship, kindly come page 18.
18, yes.
Injunction. There is one injunction, lordship.
Oh,
Dated 24th June 2019.
acha.
Page 18, lordship, of the writ petition.
What is the meaning of this, Mr. Achutip? R, page 18. By an order dated 24th June, learned court below was pleased not only pass means, not page 18, small r, your application, your institution. Not only to pass an order of injunction restraining private respondent. How is this relevant?
This is not
Why have you stated this? No, that will not. What is the relevance of this suit?
In that regard, I have a judgment to place, that is Bala Krishna.
No. First, you have to know the facts. Then judgments will come.
My only humble submission is that the work of a district magistrate is one of the only mistaken in nature.
No, not if there is an injunction restraining. Definitely not.
It's injunction restraining.
You have stated there, injunction was passed, civil suit is there. Even if a civil court passes an order of injunction, magistrate has to look into it. He's not a post office. Almost a post office, but not a post office. Yes.
Those 9 points which are there in section 14, the DM only has to look upon that, and the application, if it is found.
Have you checked out those 9 points? Read those 9 points. If there is a specific injunction, then I'll put in a 10 point. If it is not there.
Section 14 application with me.
No. Your application, you have to satisfy me on this. We cannot be blind to this. If there is an order of injunction, 9 points, 100 points, I'm not bothered. If an order of injunction is there of a civil court, that is sacrosanct. You have stated regarding these reads, not reads, civil suits. Para P, you have stated that if the court refused to pass any order of injunction. Then in R, you have stated not only pass an order of injunction. Learned counsel for the bank submits that the bank's application under section 14 of the SABYASACHI Act is pending inordinately and as per the governing procedure, since the affidavit of the bank discloses all relevant factors, the district magistrate was duty bound to pass and to dispose of the application under section 14 of the SABYASACHI Act. Learned counsel for the state hands over a copy of written instructions which indicates that it is pertinent that there are 4 cases under section 17 of the SABYASACHI Act 2002 pending before the DRT. Moreover, civil appeals are also pending before this court. Next para, it transpires from the averments made in the petition as well that several litigations are pending in connection with the subject matter of dispute. Although learned counsel seeks to impress on the court that the magistrate is merely to look into whether there is an award and or there is an entitlement of the bank or financial institution, the magistrate cannot comma, definitely, comma, shut its eyes if there is a prevalent order of injunction by a competent civil court. Full stop. Hence, comma, to clarify as to what is the position of the pending litigations before different forums, comma, including this court and the tribunal, the debt recovery tribunal, comma, the matter is adjourned till, I'm giving you till Tuesday, till December 19, 2023, when it will be listed under the same heading for the for learned counsel for the bank to clarify before this court as to the status of those matters and whether any restraint order is subsisting at present with regard to the subject matter of the section 14 application. Report filed to the Thank you. Thank you. প্রথমে affidavit of service. 11. Yes. What is the matter? Yes.
Petitioner is doing this, but there is a correction to date of birth. But petitioner applied for the correction of date of birth, submitting all the documents, Aadhaar card and PAN card.
Yes.
And after receiving all this, there was a verification date, 17th February 2020 has been verified by the department.
Yes.
Till date, the passport has not been received by the department.
Yes. What is the difficult? Yes.
I am appearing for this matter of 1 and 3 months. Permitted to
Yes. What is that?
the kindly takes page 3 and 4
Of this?
of the passport earlier submitted before all. The document submitted before. Page 3 and
Give
his PAN card is both
Give a copy to her. We rely on these documents.
These are their documents which are submitted.
Even then, she does not know. This may not be their documents also. Why do you come to put without extra copy? Anyway, what is the difficulty in this part?
Is my lord the PAN card. Kindly see the date of birth is 64. Page 4 is Aadhaar card, same date of birth.
Yes.
Page 5 is voter. This is their document that have been submitted.
You are saying there is discrepancy between the.
My lord, and kindly takes my lord page 8. Page 8, my lord, is the office memorandum. My lord. In light of the judgments of Honorable High Courts, my lord,
Yes.
this office memorandum was brought to the man. Kindly take page 8, last bottom.
Yes.
4, normally kindly takes page 9, 2. 4, 2, my lord.
Right.
So, my lord, in any case, if there has to be a change of date of birth, my lord, in 5 years and after that, the procedure is that it has to be accompanied by certificate of birth issued by registrar of birth
She
and
is
death.
an old lady. There is no certificate of birth. She came to know from her mother that she
They just place it.
Why don't we have
What is her age?
the correction exists.
What is the age? What is the actual age?
Because
75. 75-year-old person, she won't have a date of birth.
My lord, these are
69.
this,
Ask your parents and you see.
but I am not onto that. This has been done pursuant to the order of Honorable High Court.
When I is the actual date of birth, what is the fact?
You don't have anything against that, but this is as per the order of Honorable Court.
You resolve a dispute outside court and give me the an exit order. Go outside, resolve a dispute, shout among yourselves, give me an exit order. In the meantime, let me see the law. Put a short report. Put in a short report annexing this.
My
Do it just put it. Give a one-liner and do it on Tuesday.
Fine.
Give a copy to her on Monday. Please take instruction on this. 1 or 2 documents probably have to be given by you. You tell me what are the documents which you can give and which you cannot. Put this on record. Don't go on conjecture. Just first see what documents. Learned counsel for the petitioner submits that the petitioner is a septuagenarian and sought for a correction in her passport in respect of her date of birth. Full stop. However, the verification was completed on February 17, 2020, but still the passport has not been handed over after correction to the petitioner. Full stop. Learned counsel for the respondent numbers 1 and 3 contains that there are certain discrepancies and the petitioner was to produce other documents in terms of orders of this court. Full stop. Next para, in order to elucidate as to what are the documents which are to be produced by the petitioner, the learned advocate appearing for the respondent numbers 1 and 3 is directed to file a brief report annexing relevant documents in that regard on December 19, 2023, when the matter be placed fairly at the top of the list, with an advance copy of such report to the learned advocate for the petitioner.
1, 2 and 3.
আচ্ছা 1 তাহলে 1 PO 3
Great.
affidavit size filed to the paper. Please give an advance copy to her.
Great.
Whatever, please take instruction from your client, whatever document she has regarding her to substantiate her date of birth. Whatever document she has.
She has produced also. Just for correction of the date of birth, she produced passport, the Aadhaar card and PAN card, and whatever the required, whatever asked for, then she produced that.
He's citing some high court judgments. Go through that.
My lord, these documents has come through police verification, which I have shown to my lord.
Acha.
Police has verified this document and sent it to us. So these documents we are having, we have produced.
Even affidavit
And that office memorandum which later on we have published, that is pursuant to Honorable High Court.
Come back, I'll see those documents, we'll decide either.
Next.
Next. Thank you. 12. None appears for the petitioner, although the state is represented through counsel. Pushkar, let the matter go out of the list. Next. They will out of list to check immediately. They will have for a month.
Last official.
Yes, shall we? Yes.
I was late by 3 days, but I'm filing it today.
3 days. Very. 1 lakh rupee for each day. Personally. Personally, you will have to. State is poor. You are rich.
Hopefully by someday it is correct.
Very. So reply. Oh, achha, it is being.
Yes, sir.
So when do you want to come back? What is the urgency in the matter, Mr. Haldar?
Urgency, my lord.
No urgency.
Refund of the notation fees. my lord.
No, not revision.
Processing of notation fees.
No,
Not even that.
there is a mistake to transfer the amount. One is 2 lakhs.
Well,
One is
file your reply by 31st January and I'll put it on February.
different.
Yes. Any response to that?
I will take this. I'll file the reply.
I'll put the immediately after you. An affidavit in opposition filed today be kept on affidavit in opposition filed today by respondent number 3 be kept on record. Pushkar. The same is accepted on continuation of the delay in filing the same. Pushkar. The time for filing reply is extended till December 22, 2023. The matter be listed under the same heading on January 2, 2023. January 3, 2020. Where are you going? Darjeeling doesn't matter. Everybody is going to that. Even I go to that. Go somewhere else. Yes. No. Yes. What are it? Yes, Mr. Chatterjee. State took time. You are now happy. This one number? Oh, 6. Yes, Mr. Chatterjee. Oh, that.
Yes, whether he can give compensation and if he can give them how much before going deep into the matter of last filing the few compilation of few citations upon which I shall rely. And then my lord, this schemes, this is the compilation of two schemes. One is formulated by the state government and another is now such scheme. My lord, first, my lord, let me place the present case. He is a male accidental victim. His face has defaced, but my lord, it is stated that 44% disability. 44%, but defaced. My lord, still several plastic surgeries were done. Still 4 to 5 numbers of plastic surgeries are required. On 25th of January 2017, he received rupees 3 lakhs from State Legal Services Authority. In page 105, I have annexed that. Thereafter, petitioner filed an application before the District Magistrate South 24 Parganas, praying for additional compensation. And I have also annexed another document, page 109 and 110, wherein it is stated that 2 other accidental victims, they received rupees 7 lakhs each from SLSA. Not only that, on the last
They were also males.
no, female.
Achha.
On the last occasion, she was also kind enough.
Mr. Chatterjee, now there is a specific scheme. Your entitlement, you are claiming divorce scheme because the scheme says only about female victims.
My lord,
So you are under general law.
Yes,
Or fundamental right, whatever. So you are not covered by this scheme.
No, and my lord, I am covered by the word victim, as it has been stated. And my lord, under section 357 capital A of criminal procedure code,
Cite those provisions.
my lord,
First victim, then 357. Victim in their scheme.
victim, my lord,
The victim under which CRPC? Or?
CRPC. Victim,
So you see, you also come under the victim compensation scheme and all this.
my lord.
Satisfy me on that. Criminal procedure code.
Section 2W3.
Criminal procedure code.
No, my lord, criminal procedure, CRPC.
You have forgotten what is this criminal procedure by saying CRPC. Two double A.
WA.
Oh, WA. W, yes.
The year 2009,
Yes.
this section has been incorporated by
Mr. Coroner, you please take your seats. Yes.
this particular subsection has been incorporated in 2009.
Right.
Victim means a person. Person is gender neutral.
Hmm.
Who has suffered any loss or injury caused by reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir.
So his or her.
His or her.
Very good.
My lord, this is victim. Thereafter, my lord, victim
Compensation scheme.
57 capital A.
Yes.
357 capital A.
Right.
357 capital A. Victim compensation scheme.
In fact, the language used is his.
Yes, my lord. Every state government or the central government shall prepare a scheme for providing funds for the purpose of compensation to the victim or his dependents who have suffered loss or injury as a result of the crime and who require rehabilitation. Then, whenever a recommendation is made by the court for compensation, the district legal services authority or the state legal services authority, as the case may be, shall decide the quantum of compensation to be awarded under the scheme referred in subsection 1. If that initially it was stated that after conclusion of the trial, payment will be disbursed, but thereafter it was seen that sometimes accused are not arrested even, especially in affiliate victim cases, because they were unable to identify initially because they were in so pain, they were not able to see who are the accused persons. So thereafter there are citations also wherein it is stated that during pendency of the trial or whenever the accused are not arrested even, then also this compensation can be granted. This part goes. Now, my lord, kindly comes to the compilation of the citations which I have placed before your lordship. First, page 1 to 5, Lakshmi versus Union of India. This was the basic judgment, the year 2014. It was passed 2014, volume 4, SCC 4-7. Relevant paragraphs are paragraph 12 to 15. My lord, what happened initially when this case was filed? Lakshmi filed this case before the Honorable Apex Court. Honorable Apex Court, my lord, demanded affidavits from different states and stated how much you can pay. There, Honorable Apex Court found discrepancy when Bihar said that we can pay up to 25,000 only. Rajasthan said that we can pay up to rupees 2 lakh. Then Honorable Apex Court observed this will not do. There must be a conformity among all the states. Then Honorable Apex Court stated minimum 3 lakhs have to be disbursed immediately. Thereafter, as and when required, money has to be disbursed. Well, it kindly comes to paragraph
14 says that.
Yes, paragraph 14 says that.
Very
We accordingly direct the affidavit of victims, here male or female not stated, shall be paid compensation of at least rupees 3 lakhs by the state government union territory concerned as the aftercare and rehabilitation cost. Of this amount, a sum of rupees 1 lakh shall be paid.
In your case, 3 lakh has been paid to you.
3 lakh paid.
So let us proceed.
Thereafter, then I am not reading the rest. Thereafter, my second citation is Parivartan Kendra, 2016, volume 3, SCC 571, paragraph 17,
19, 20, 21. Paragraph 17, 19, 20, 21. Very specifically, my paragraph 21, here analysis was done. Paragraph 21, I'm reading from the middle portion.
Yes.
The court has the power. I'm reading, and the line starts with from the middle portion. In consideration of the severity of the victim's injury, expenditure with regard to grafting and reconstruction surgery, physical and mental pain, etc. We are of the opinion.
No, this is para 21.
Para 21. Para 21 middle.
It is also noticed to be noticed after that.
It has, yes. Next line.
In the instant case.
Next line is in consideration of the severity of the victim's
Yes,
injury,
yes. Please continue. Yes.
expenditure with regard to grafting and reconstruction surgery, physical and mental pain, etc. We are of the opinion that the victim Chanchal should be compensated to a tune of to at least rupees 10 lakhs. Suffice it to say that the compensation must not only be awarded in terms of the physical injury, we have also to take note of the victim's inability to lead a full life and to enjoy those amenities which is being robbed of her as a result of the acid attack. Therefore, the court deems it proper to award a compensation of rupees 10 lakhs and accordingly so and so. So, honorable court has the power, my lord, to award compensation. Why I am saying, my lord, state victim compensation scheme. If your lordship kindly take the state victim compensation scheme, there it is stated of rupees. Is stated in only rupees 3 lakhs. But my lord, NALSA stated minimum 7 lakhs and maximum rupees 8 lakhs. Unfortunately, on the basis of NALSA scheme, state they have not amended their scheme. So state they have stopped over there up to rupees 3 lakhs.
NALSA scheme is binding on the state. Not
binding.
They operate parallelly.
And not only that, it has been.
If it's beyond the scheme, can we do that? I mean, that is what. Because you will get, another person will not get, there will be a disparity.
As well as few days back, coordinate bench of our honorable court, my lord, observed that the state has to be, they have to amend their scheme.
I agree, fully agree.
Yes.
But before that is done, can we direct? That is my question.
My lord, direction, not this observation or my lord, this desire of the honorable court.
We can seek a report from the state also on, from the state authorities about this scheme. I mean, whether it can be enhanced or not.
My lord, if your lordship sees paragraph 21 of this, which I was reading, my lord, there my lord, certain parameters were considered, but saying that compensation should be increased. It was said that compensation should be increased, but that was not done. That is my humble submission before your lordship.
These are case specific. That's why, Mr. Chatterjee, I'm saying, because you will get something. I direct you of my victim to be paid 20 lakhs. Another victim gets only 3 lakhs. I mean, there should not be a disparity of that. Yes. There should be a minimum of that. Minimum. Everybody should get the benefit.
And regarding male acid attack victims, there is no specific citation.
Need not. Whatever you have placed, Mr. Chatterjee, is sufficient for.
My lord, last word I showed you another citation.
Yes.
Nipun Saxena. This is also very celebrated citation. 2020, volume 8, SCC 499. Relevant paragraphs, paragraph 7 and 8. Nipun Saxena, my lord, this case.
Tell me something before proceed with Nipun Saxena. This the West Bengal Victim Compensation Scheme. This scheme has been framed under 357.
Yes, under 357.
Under that. Very.
Nipun Saxena, in paragraph 7 and 8, it is stated. Paragraph 7 and 8, page 35 of my compilation. We have gone through the scheme prepared by NALSA with the assistance of the learned Amita Skilli, and here of the view that it contains the best practices of all similar schemes and should be implemented by all the state governments and union territory administrations. It should be implemented by the state government because they in 2020. A copy of the scheme should be sent by the Ministry of Women and Child Development Government of India to the principal secretaries of the state government and Union Territory Administration within 2 weeks from today for implementation. Nothing was done. We make it clear that the scheme postulates only the minimum requirements. This does not preclude the state governments and Union Territory Administration from adding to the scheme. It was stated that some more can be added. Not only that, my lord, your lordship knows everything. In the earlier judgment, your lordship was kind enough to direct the state government to pay pension. My lord, your lordship knows how painful is the surgery. Not only that, my lord, in the summer, my lord, the skin comes out after the surgery even. So, my lord, they need constant, my lord, one healing touch from hospitals. And
So
nursing
in
homes.
the state scheme, is it mentioned specifically that this is for male victims?
No, in state, my lord, that is not.
That scheme is at page 16, 16 to 18.
Definition of state scheme.
The para 3 says to help women victims. Ministry of Home Affairs, probably. MHA has issued guidelines for central government victim compensation scheme fund scheme to help women victims. Clause 3 of the state scheme.
Clause 3.
Hmm.
Well, clause
Page 16.
No, that is well probably NALSA scheme. Well, state is the next one. Next. Now after
No,
NALSA
16 is state scheme. Government of, yes, but the number, then pagination is wrong.
My lord, I am reading from the state scheme.
No, your pagination is 16 to 18 in my copy. That's a different pagination. That's an answer.
I'm extremely sorry, my lord, for this.
Pagination is probably up.
Second part is the state scheme. First, I have
No, page 16 in my copy. Page 16 is this 9th November 2016. That's a central. That's a part of the central scheme.
that's a part of central scheme.
Ministry of Home Affairs. Probably. Yes,
No, that is Prime Minister's fund. That is also an scheme.
that's different. Very.
My lord, I am reading from the state scheme.
Yes.
That is the second part.
Person.
The definition to GHI. Victim is a person.
Person. So it's in consonance with this.
Yes. And there are the victim compensation fund. There also, my lord, that is also gender neutral.
So you are relying on Nipul Saxena also.
Victim success also I am relying.
And
Thereafter, my lord,
now show me the NALSA scheme. The rates stipulated by the NALSA.
NALSA scheme is in page 61.
No, in your compendium. Give me your page number, I'll find out.
NALSA scheme, my lord, 30, text 30.
So acid attack is 8 lakh,
Yes, 8 lakh.
but it relates to women. Applicable to women victims.
And my lord,
So Nipul Saxena goes there. Nipul Saxena, if it says that this has to be implemented, it has to be regarding women then. So you cannot rely on Nipul
no,
Saxena.
Nipun Saxena, my lord, stated regarding gender neutrality.
No.
Nipun Saxena particularly.
Nipul Saxena, the specific language is we have gone through the scheme prepared by NALSA with the assistance of amicus curiae, and we are of the view that it contains the best practices of all similar schemes and should be implemented by all the state governments. It does not speak about victims. It says about the scheme prepared by NALSA, which in turn pertains to women only. So that's a women victim scheme.
I shall I shall stress upon words that it contains the best practices of all similar schemes and should be implemented by all the state government. Here I am asking myself whether it can be done in case of male victims also. Whether it can be done in cases of male victims also.
But that is not a direct outcome of this judgment. That is not a direct conclusion we can get.
Only
But this is not a precedent for that.
not that.
This is only regarding the women's scheme of NALSA.
Because my lord, most of the victims are female victims. But sometimes there are the male victims also.
Yes, I mean, why shouldn't they? There may be, they may very well be. But I was wondering whether I mean, isn't it the discretion of the state How can the court interfere there?
My lord, then my lord, I shall
I mean,
face a
it's a question of policy of state.
citation of.
Women require certain extra protection undoubtedly till now. There is no doubt on that. Unless you are in the creamy layer. Now, acid attack victims generally are not from the creamy layer of society. So, I mean, it's not a discrimination. It's a support with the
Kindly
women.
allow me to read another citation which was passed by our coordinate bench, my lord. That is, I have annexed in my compilation.
Paramita Bera.
Yes.
Yes.
Paramita Bera.
Yes, show me that.
Not exactly stated in the same tune, but my lord, I am trying to give something positive in my favor. Page 37 onwards.
What Bengal thinks today?
Huh?
What Bengal thinks today?
Yes.
Yes, isn't that? I read this in live law somewhere.
Yes, my lord.
Yes.
Here, my lord, all the citations were discussed. Paragraph 19, 20, 21.
So show me your best paragraph in this judgment. This was regarding a male.
Paragraph 7.
This was regarding a male.
No, not regarding it. But what are the observation? I'm showing your lordship. The honorable court can do this, my lord.
So there is a positive gender bias here against males.
My lord, I am trying to show some portions are vacant. Your lordship has to feel that.
How is that this judgment, I mean, helpful to you?
My lord, in this case, my lord, maximum portion was given, though that was not stated in our state, my lord, scheme, but rupees 7 to 8 lakh rupees.
Mr. Chatterjee, there is no doubt if it was a woman, then definitely the schemes come, everything comes in, falls in place. So in the previous order also, I directed 8 lakh. But there is no problem there. The only problem is there is no scheme for male victims. That is the cardinal problem. And my question is how far we can frame policy on behalf of the state, because they are the elected government.
Your lordship can direct the state government regarding their thinking about the male victims.
I can seek a report at best regarding the possibility of exploring such.
No, sorry, my lord, I bow down before your lordship.
Yes.
My lord, presently, my lord, as per NALSA scheme, my lord,
Only women.
For women, but whether at par amount can be given to a male also.
You are adopting two myths, judicial fictions. One is that NALSA scheme should be followed, and at the same time that it should be applied to males also. Males does not come in that. NALSA scheme, whether that should be followed for women, yes, that's a valid discussion. But for males, it's a different ball game altogether. And we have to put something into the legislature's mouth which is not there. If the legislature does not think it fit, neither the parliament nor the state legislature, mind that. If they don't think it fit to give it to male victims, how far we can force them to do that or direct them to do that?
Direction,
that's directly.
direction can be given.
No, Mr. Chatterjee, that is precisely we can express our hope, trust, views. These languages can be used, but we cannot direct.
I have stated how, my lord, the day-to-day basis, the expenditure, how.
Mr. Chatterjee, there is no doubt on the expenditure, on your plight. There is no doubt on that. We are not on that. We are on a pure question of law. How far we can include into the legislative domain. This is policy of state. Either the center or the state, whatever. This is the legislative policy of state. Whether they want to implement these schemes for men. Now there, it's entirely within the domain of the elected government.
But if
we don't frame laws, we interpret laws.
Victim, the word victim, then state is bound to pay. If we come within the purview of the particular word.
So you say we can direct them to frame a scheme for males,
yes.
Gender neutral.
Not only that, at the side by side, if some amount can be disbursed. Why I was saying about Paramita Bera's case? Paramita Bera's case, they did not prefer any appeal. Though that was not within the purview of state scheme, they disbursed the amount. That means state also, my lord, can disburse the amount if a direction can be given from this honorable court. Paramita Bera's case, 8 lakhs they have given. That was not.
Paramita Bera was a lady.
But that was not that has not come within the purview of state scheme. Still, my lord, they have given. Had it been a case that they have challenged in appeal, then I could have understood.
No, you have a point here also that the state scheme also says victim, which is not restricted to a woman.
In Lakshmi's case, Parivartan Kendra's case, it was stated that 3 lakhs is the minimum. You can pay if.
You're not getting the point, Mr. Chatterjee. You're not getting
I
the
understood.
It's not a question of quantum at all. The state scheme, the point is different. The point is that the state scheme itself says, defines victim as a person. So if that be so, so they have to frame a scheme then for men also, or gender neutral.
I'm grateful, man. I'm grateful.
Let me ask Mr. Corona.
My-
Yes, Mr. Corona. Before you answer my questions, let me frame the question. Please come to this compilation of schemes. Have you got a
Just now
copy?
I have received this.
Yes, just now I have also received. Let us not say these things.
My lord,
Please open that page. Just now also I have received. So what? This is a question of law.
some time is needed.
No
to go
time.
through there and I will deal with this man.
No, please come to the state scheme. This is a pure question of law. You have to be ready. Everybody has received it just now. I also received just now. So what? I'm not asking you to give facts. Please show him page 19. Give him a copy. Page 19, Mr. Kaur. 19, please come to definition 2I.
They've given him a copy.
Victim means a person.
Victim means a person. Victim means a person. The entire thing derived from the Supreme Court judgment, but the basic issue was to give compensation to the lady victim. This is woman centric. The entire judgment, which derives from the Honorable High Court, which is passed by the Honorable High Court, then the different High Courts, Honorable Supreme Court, and there are different High Courts, all were women centric. Women centric, and this has been given for the rehabilitation and for the treatment and other things for the women, so that they can come back in the society, they can survive, they can lead a respectful life in the society. This is the motto of the judge. But here, my lord, in this case, my lord, already, my lord, the state legal service is the ultimate authority to give compensation as per the direction of the Supreme Court, as well as the thereafter NALSA.
Mr. Chatterjee, when was a copy of the writ petition served on the state?
The state has been served, and my learned friend is appearing on behalf of the minority.
So why are you not ready, Mr. Karan? Why are you not ready? It was served in June. Why are you not ready in the matter?
Today I have only received this judgments, my lord.
Judgments, you are not supposed to get the judgments. They only give the citation. When an argument is made in court, Mr. Corona, citation is given to the judge. If not even to the judge, they can only refer.
You have to deal with the judgment, whatever
Deal right
they
now.
have raised.
Deal right now. We are in the midst of an argument. We cannot, in every matter, if you give time to the respondent to deal with the judgment, Mr. Karan, that is unheard of. If it's a factual issue, definitely I would have given you time. An argument of law has been made in court. Deal with that. You have to deal with immediately.
It is really a policy decision of the government. And the government has framed 2017, my lord,
Let us come to the policy once. It has been annexed by them.
policy decision.
Policy says victim. Policy says victim is a person. And it has been framed under the victim compensation scheme under section 357A, which also speaks about a victim.
357A also speaks about it.
Exactly. Everything speaks about the victim.
And the very basic of the judgments, where from it is derived.
Woman.
Yes. Lakshmi was not women centric. Lakshmi was gender neutral. Hereafter, subsequently,
Even then, most of the judgments are women centric.
Women centric. But
Let us share this.
State legal service authority is the authority as per the scheme. They have already, this is a male victim. So they have already paid
3 lakhs.
They have 3 lakhs already.
Which is
paid.
the maximum
So
amount.
I am not in a position to defend it like this, so that it is only for women, only the woman.
Very well, let us hear the women now. Yes.
She starts, well, I have one thing to show. Well, in state, it was stated minimum, not maximum.
minimum amount of compensation state, the Supreme Court has said, SLC is not the Supreme Authority. State is also
Charity, I've seen that.
SLC disbursing authority.
Yes, SLS, please add.
But as per the legal section of judgment, Supreme Court has fixed the minimum amount that has to be 3 lakhs. And then 3 lakhs, 7 lakhs, 5 lakhs, it depends on different parameters. Parameters of the
Parameters of the judge,
no,
parameters of the
parameters of- I'm not
advocate.
the parameters of the not
What different
justice or
parameters?
the-
What
different parameters based on the gravity of the
attack? Acid attack, definitely.
accident.
Right? There you are absolutely right. So let us
So
see.
one, there cannot be a parallel. There cannot be a 100 first.
That's not a parallel, that's a horizontal.
8 lakhs have to be given in each and every case. It depends.
Yes.
From your lordship, we are governed and state legal services authority is governed by the West Bengal compensation scheme lordship. Of course, in some matters lordship, there is a direction as a Parmita Bear lordship, there is direction to follow the NALSA scheme and state legal services is bound to pay the amount lordship, but there is no state policy that that will follow the NALSA. So we are governed by this state West Bengal compensation act lordship, and there is a minimum amount for the acid attack victim is 3 lakh lordship, that we have disbursed lordship. And as your lordship please lordship, we can follow lordship, but there is no specific guideline lordship for it.
How do you get over nipple suction? Nipple suction is very specific.
But lordship is
Nipple suction speaks of women, but speaks about the NALSA scheme and says that should be followed in the states. Now, our state, like many other states, has a scheme. So, if that is to be followed in the scheme, that has to be incorporated in the scheme. Our scheme is in fact one step ahead of NALSA scheme, in as much as this is gender neutral, which is one step ahead on that front. But regarding the money, I mean, how do you get over this nipple suction? If the NALSA scheme is to be followed by the state scheme, our state scheme should have similar rates at least comparable rates. The central scheme says 7 to 8, and we are saying minimum 3 is all right.
for that lordship, state has to make the policies lordship. State legal services authority cannot make the policy lordship.
All right.
And my instruction there, I'm not opposing that he is male or female, because
No, I
already
understand.
less he has disbursed.
Yes, you have disbursed and admitted that, is it?
And lordship, only my one submission lordship.
Yes.
If you lordship kindly come to the NALSA scheme lordship.
Yes.
There is for accidental maximum upper limit for compensation is 8 lakh lordship.
Yes.
And if you kindly come to turn the page lordship, there is in case of injury more than 50% or less than 50% lordship.
Yes.
In repetition paragraph 18 lordship, 18, 19 lordship, there is disablement is 44% lordship. Page 18. Page 19 lordship, 44% permanent physical impairment as per guidelines,
Yes.
44%.
That we said also.
In that case, lordship, in case of injury less than 50%, there is minimum is 3 lakh and accident is 5 lakh.
Achha, is it on the percentage of disability? Let us check up the NALSA scheme. Next, Miss Chatterjee, let it come.
30 days lordship.
It is not there. If you please come to page 13 of their compilation. It's not percentage of. In case of disfigurement of face, so therefore it's different. Not on 44%.
And as there is upper limit is 8 lakh lordship, we have already reached.
Yes, that we have.
And what is in the repetition? They have only repetition. They have only ballot. You are also trying to come to the page.
So you have literally grown wiser.
You are also trying to come to page. Page 106 of the report.
Yes,
This is their only prayer. They have asked 1 lakh only from the Prime Minister Relief Fund. The final prayer that they are
is reflected there. Let us see that.
Much impact.
Yes, yes. Single eye. only a single eye has been tapped. Yes. 44% and the very next column, there's a tick mark, reassessment of disability, and after that, for example, single eye has been ticked. And even the picture apparently that it is at page 18, the picture shows right eye.
If that is considered as less than 2%.
Wait, please take your seats, elders. Mr. Chatterjee, let us start with this page 18-19. Your disfigurement is not complete facial disfigurement. Only a single eye.
What a single eye affected along with the face, one side. I am not pressing for seeing the photo, but I have annexed one.
No, your disability certificate. Where is the photo?
Page 17.
17.
I do not know how 44% has been given, but this is the injury interface. Defacement is there. How 44%? With that assessment, the record shows, but the picture shows whether there is
But not complete facial disfigurement.
not complete. Not by earlier case was
44% is Mr. Chatterjee reasonable. Because I'm feeling very awkward to discuss a person's face like this. But even then, we have to do it objectively. Now, here, if it was the entire one side, then it would be 50%. Going by that premise, 44% seems to be, reasonable and a reasonable assessment.
I have stated that 4 to 5 more surgeries are required. Eye surgery as well as skin grafting. Not to make the face more
Attractive.
not that to be alive,
Survive.
to survive.
Very good.
I'd like to topic, I thought that was like discussed in this way.
No, even then.
Is working lordship, it's a parafuture lordship. It's not like that it's totally, out of requirement. Kindly funded, we can do something, but I'm bound to something.
He is employed in what? Yes.
It's mentioned lordship by operation strategy and primaries. That means he's not out of total employment.
Great. Yes.
Sir, in this regard, I would like to submit another thing out of that. There is one person, my lord, who spends crores of rupees behind him. I would like to tell this, I do not want to take his name, but during IPL he comes. He takes those persons, these accidental victims to his hotel. They stays together, and my lord, he takes these persons to plastic surgeons and spends crores of rupees thereafter. Goes there, no one knows his name. Only for that person, these persons are alive.
Mr. Chatterjee, that
But my
part of it is state funds are limited. And whatever may be our personal mission, we cannot go on that. Whatever is the total fund, it is limited ultimately. So there's a Veblen effect. There are several economical theories. Now you have to allocate funds. So when you allocate funds, it's a state policy. Yes, definitely substantial funds should be given. Why to acid attack victims? To many other sections of society.
I personally appear for SLSA.
You appear for. So there are several sorts of people, categories of people. If you want to fund them all, it's not possible for this. So it's ultimately a state decision. So therefore, we cannot go too far on that for a particular person.
Let me as our state scheme as well as victim, the definition of victim, it is stated that minimum is 3 lakhs. Let a hearing be given.
Mr. Chatterjee, I'm telling you, I'm indicating to you. The crux here is, yes, your best argument is apparently subject. That our state scheme is gender neutral. It is under section 357A, which is also gender neutral. So our state scheme is gender neutral. At the same time, it also operates within the purview of NALSA in view of Nipul Saxena's decision. The rates have to be considered on equivalent premise as NALSA rates. So their male victim also comes in. Even for male victims, which our state provides for, the rates should be near about NALSA. Now, regarding your personal case, yes, we can give them another opportunity to consider your case by taking into consideration the expenditure which you are making for your particular case. That can be the best
Hearing
judgment.
placed by the member secretary will let him, my lord.
Yes, definitely. We can see to that a hearing is given to you. You will be able to place your documents, and we can put in something in our order also that the subsequent treatments also are to be looked into. We can put something in that order. So I'll do that.
At least we'll a few amount of, it can be directed, my lord. I'm not praying for huge, my
No,
lord.
I
It
understand.
can be directed.
Understand. Good. So
But my
I'll,
lord, this is required for male victims also. my
male
lord.
victim
We have-
states provides. I'll hold that. I'll hold that. It's gender neutral. Our state's scheme is gender neutral. I'll just think it over and I'll give another thought. Good. Hearing is concluded, judgment. Come back in 10 minutes for the next. Yes.
But I'm not sure.
Yes.
17, 18, it's the analogous.
You're appearing in all, Dr. Shara? All the three. Yes. What is the matter?
The petitioner is a developer. He purchased one of the plot and the developing the properties. Now, in item number 16, my plot situated just like the subdivision of Kota. I have a residential complex and there is a vacant land where I proposed to construct a commercial. All of a sudden, the respondent authority came and trying to install a transformer just at the need of my vacant. Now, the most surprising fact is within a week, all three properties of mine within the town of Kharagpur, they are installing transformer in front of my land. That is mine at 16, 17, and 18.
Different places.
In different places.
It's a political thing.
But I don't want to say anything beyond the record, but there is a malfeasance. I have annexed the photographs
In different places.
in different places.
So what is your relief?
Not presently, in terms of this work of license rules, if I am raising objection, they have to approve the deed. Presently, I am asking for an interim order because the transformer has not yet been effective. The connection has not yet been effective.
Yes.
There is no personal development direction, but there are several places. What is the scheme? A scheme has been taken place by the West Bengal State Electricity Distribution Company at different locations in the Kharagpur municipal area. But it is for the base purpose, for the safety measures, the high tension overhead line has been converted into high tension underground. And for this reason, there were several rings. There is a scheme it is called ring main unit, because there is a certain place where the connection is to be made at different places. It is not that it is only the place of the petitioner. There are several other places where this connection has been made. Where it has been made to meet the main purpose is to doing for that is just to make an underground line, high tension underground line. It is for the public interest, for the entire.
So they are agreed with the transformer.
This transformer has been used. This is not a transformer. This is the ring main unit which has been installed at that place. Different places, not in the place of the petition. There are several. And what happened that there was a discussion, detailed discussion made with the municipal authority, SDO. Thereafter, we have installed in that place. And it is not in the land of the petitioner. It is in the PWD. What my landed friend is stating that it is within his land, it is in the PWD.
First item is not within the municipal area. This is within the panchayat area.
But this is
Since when did the project start?
a long time back. It is a long time back. It has been.
Mr. Bhattacharya, you want to stall a public project.
They are trying to install the
I have made a representation requesting them
Go to the district magistrate to take up the point.
for the license because in terms of the rules they have if they want to install in my petition what is within the PWD rule to encroaching my land.
Yeah.
In terms of these rules, they have to.
You are right. They have to go to the district.
And they have to take permission from me. Here, the land is not the land within the periphery. My land includes my inventory right also. You can, I can understand that they can install for public project. They can install at the side of my land, not for at the middle of my land.
That it is not within his land.
That's distributed.
But he is saying that if he has been agreed, he could have approached there. But the rule says under
Who says
but he says that
who
within
can
his
license?
land.
Rule is that unless you obtain consent from them, you have to obtain an order from the district magistrate or the commissioner of police.
It is within the land of the petitioner. My dispute that it is not within the land of the petitioner. But let him produce that record before the authority that it is within the land of the petitioner.
Yes, I'll give him that record.
Yes.
The three writ petitions are taken up together, since the petitioner is the same and there is identity between the allegations made in the three. First up, the petitioner alleges that the WBSEDCL has been installing transformers planfully on
By being may in
The properties of the petitioner, comma, situated in different parts of the Vidnapur town of Kharagpur, comma, which are not even in close vicinity of each other. Pushab, it is contended that under the Works of Licenses Rules, comma, 2006, comma, unless a prior consent is taken from the owner or occupier, comma, and or a permission has to be obtained by the licensed police. First up, in the present case, comma, the petitioner never gave any consent and such procedure has not been adopted by the WBSCDCL. First up, as such, comma, the petitioner seeks intervention of the court. First up, next parallel, counsel for the WBSCDCL denies the allegation that there is any plan or motive behind different properties of the petitioner being subjected to installation of transformer. First up, the said installation is not of a transformer but of a ring main unit, comma, which is
the high tension line in front.
which is the part of a larger project covering entire Kharagpur area, comma, for converting high tension overhead lines to underground lines. Full stop, next para. It is also disputed that only the petitioner's lands are being targeted, and it is submitted that that transformers have been installed in several properties. Full stop, next para. It is also disputed that the properties in question, which are the subject matter of the present petitions, comma, belong to the petitioner, whose learned counsel for the WBSCDCL contends that the properties on which such units have been installed belong to the PWD and, comma, although may be adjacent to the petitioner's property, but do not belong to the petitioner. Full stop, next para. Such allegations are, comma, of course, comma, further controverted by the petitioner. Full stop, next para.
I can provide my own land beside this to install the transformer, just keep the front portion.
Obviously, comma, there is a dispute as to the ownership of the property where the units are being installed. Full stop, next para. However, comma, the said dispute cannot be resolved within the limited confines of the writ code. Full stop. As rightly argued by the petitioner, comma, Rule 3 of the Works of Licenses Rules, comma, 2006 provides that a licensee may carry out works, comma, lay down or place in electric supply line or other works in, comma, through, comma, or against any building or on, comma, over or under any land, wherever or whereunder any electric supply line or works has not already been lawfully laid down or placed, comma, the italics say, with the prior consent of the owner or occupier of any building or land. Push up, next para. Clause B of Rule 3 within bracket 1 provides that in case the owner or occupier of the building or land raises objections in respect of works to be carried out under the said rule, comma, the licensee shall obtain permission in writing from the district magistrate or the commissioner of police or any other officer authorized by the state government in this behalf for carrying out the works. Next para. In the present case, comma, although the ownership of the petitioner is not admitted by the WBSCDCL, comma, since a dispute has arisen and an objection has been specifically raised by the petitioner by giving representations, comma, it would only be appropriate if the matter is decided before the district magistrate. Full stop, next para. Thus, comma, WPA number are disposed of by granting liberty to the petitioner to approach the concerned district magistrate with the dispute as raised in the petitions within a week from date. Full stop. If such an approach is made within a week, comma, the district magistrate shall give an opportunity of hearing to all concerned, including the petitioner and the licensee, and decide the dispute between the parties, comma, preferably within January 15, 2024. Full stop, next para. Till such decision is taken by the district magistrate, comma, the WBCDCL shall not further proceed with the
Already what has taken place, what the implementation has.
shall not further proceed with the work in question, comma, since no permission was taken from the district magistrate or commissioner of police in the first place. Full stop, no orders to proceed.
Well, implementation has already taken place.
No further, nothing further.
But stating
I've disposed of the writ petition till it is decided by the magistrate. 15th January.
I can add the
Yes.
That matter of that it's the number of data works, but data of the physical calculation has not been submitted. So they have highly limited, there is no subscription. Option of speech directly by the order that is not.
This was the ploy which was adopted by Mr. Bandyopadhyay's plan. Ploy to delay. Yes, what does your report say, Mr. Bandyopadhyay?
Report, but prosecutor's report, but.
Opposition. Yes,
But, the first page, there are disputes.
I'll ignore that. Yes.
But,
No, what is you have a dispute regarding the claim?
The dispute we raise in the demand of money by the petition. And we are trying to demonstrate that where there is a mismatch with our record, why some claims are barred by limitation, and why where some payments have already been made but not disclosed by the petitioner. And in effect, what I need to say is that why it requires charge and difference. Why a simpliciter money claim should not be entertained by a 26 court order, that will be my argument, and this affidavit will be in support of that.
Yes, Ms. Das. It's a money dispute. Disputed fact.
No, because it is the money back. I am relying upon their certificate. They have issued, who has the, filed the certificate that is, assistant engineer,
Yes.
Atul Bhalta.
Where is that? Where is that?
Their opposition, Atul Bhalta has filed a certificate. That means that he is the assistant engineer in the municipal corporation. But why I am this speaking certificate? How they can say that it's a mismanaged, so I am relying on their certificate, whatever amount is there.
Please show me their certificate, Ms. Das.
Number of certificate, we can take subsidiary number of certificate, that is page 21. Again, that is issued 8 May 2023, issued by the executive engineer, which is written and left side column below, that is Atul Bhalta. Here is the work order.
Ms. Das, you have to prove this requires trial on evidence because you have to prove this document. This report cannot take evidence. I cannot call your client to doc and prove this document. You have to prove this document, the original of this.
They have already prepared an appeal. I have already annexed. Applicant also.
Show me that. Show me that.
To my department. Can you see this?
Reply. Between the same for the same petitioner.
Not accept for the municipal corporation also responded and number of another contract. They previously they came to the court and the city bench.
Where is that order of the single bench?
That is not. I have already annexed to my department. And can you see the page 9? That is the division report.
Pagination is not there, but it's very well. The first annexure, the first page of the annexure.
That is the interport capital. It has been created against an order in July 2019 caused by learned signature of this court such and such and can be supported. We have heard the parties and taking the appointments in this application. Also is sufficient late. That is not. Now that's why hearing that we have heard the parties on the meetings of the appeal. With their consent and propose to dispose of the appeal here and now. Dispensing with all the formalities. It appears the lead jurisdiction of this court was invoked by the respondent number 123. By the defense that they had issued work order by last word given number municipality for beautification such and such work. And it was claimed by the respondent number 123 that though they had executed the work entrusted to them by such work order to the intersatisfaction of the municipality, they had not paid their dues despite numerous inspection made from their end.
municipality and subsequently the corporation declared in silence. The report having been acknowledged, application was issued to the executive engineer that is suggested to prepare the bill on the basis of the measurement bill that follow the same documents considered in the constitutional contribution for disbursement of the same amount. Sir, which is directed to complete within the period of 2 weeks from the date of publication of this order. This is the second reason. Revision of the income order because the despite service come to the corporation, we do it undifferentiated before the largest job. Though the appeal was filed by them, having had the larger advocates for the project user of the target are arguing supplies of the by disposing of the requisition with mandatory injection in the absence of the corporation of the bidding for the same control. Such an approach in the teeth of the decision of the Supreme Court certain within the government of the year and it coordinate each decision of this court. Shaktasha High School versus Krishnaram Bhattacharya and others reported certain in view of the matter. The order includes that set aside, but they have already entered. We do not see them to demand the petition for their hearing. Interest of the justice in our view the subject to start in the commissioner of the corporation act. Number 2, proceeds to consider the petition of the respondent number 1 to being access to law and after granting an opportunity of hearing to the respondent number 1 to 3. In the event the commissioner is the opinion that the respondent number 1 to 3 had executed the work entrusted to them fully and to the satisfaction of the corporation, release of the deeds of the respondent number 1 to 3 shall not be unduly delayed. However, if the commissioner is of the view that the execution of the work by the respondent number 1 to 3 is deficient of any count or there are other cases for which release of the payment claimed by the respondents 1 and 2 or in part would not be permissible in law, order shall be passed and communicated to them.
You'll be satisfied with the similar order?
Because I made a position because law certificate says, and this is not issued by me. After completion, there is no allegation that what is defective. Each and every document can be seen. They have both their signature. They cannot deny it. You can not only deny it that they have not issued the certificate, on the basis of certificate, whatever amount is mentioned. That is called a pencil, that is page 23. What order? Thereafter amount to India, thereafter on the final page 29 lakh, thereafter final page amount to GST, and date of commencement, date of completion, date of actual completion. And the certificate issued that is the first. How to start with this is a single one. Can you see the next? Page 25 also.
25 to 28, 27.
25, 27, and
26, 25, 26 and 27.
yes. So that is the
No, 26 is what?
that is the certificate. That's the important.
Yes, it's 25 and 28, 7 and
And now the director that is not at all submitted. They did not attribute the papers because I have made the submitted. I have already stated that 5 lakhs I have received. I have not submitted. I received this. That is one on page 22. Page 22, and it's a P.
yes, yes.
Payment due 32 lakhs 99,753 total 56 plus 5 lakhs. So there is no future submission. I have already disclosed.
That means just how many certificates are there you have annexed? Page 25, 27 and 22 also.
23, 25, 27. And plus page 55 can be also seen. Though they have not issued the certificate under this side already made clear reporting, they already signed that is a certificate that the work has been completed as per specification and satisfaction. After issuing the measurement book, they have issued what is the date that is equal to 19,180. This they are the books. Page 55 now. And there are the page 57.
57 another certificate.
Yes.
Yes, 57.
The book content has completed the work.
There are several other certificates. Page 61.
61. All certificates have been signed by the opponent. So how we can deny it? This is signature and not only the individual also. What has been completed? So on that issue that with the money they cannot be taken, but on that issue only I think it's by the honorable. And why this is.
I could directed them to only consider the representation. That won't do. You are asking for the money. You want to see the color of the money. Those judgments do not apply in your case. Those judgments merely direct them to consider the representation and to assess the sum, and you are on a higher footing.
Already assessed after that. Assessment already done. It is their consideration. It is their document. And you have to pay that. What you were mentioning in the certificate.
That is why I am asking you which are the pages of the certificate. Because those are the claims on which they have issued certificates. Page 67 is there. 60. 61, 65, 67, 16, 70.
Yes.
Apart from that, anything else?
I am not asking more of what is the reason there and the guarantee to raise it.
Right.
After the consideration, what amount of fee? There are two competition certificate.
Right.
And this is not correct. I have started not only that 5 lakhs and as well as we have hospital I have already aggregated. Not only that we have conducted aggregate and approve into the permission, but they do the supply they have to come. And I am running since July 23. But each and every day the supplier are coming knock the door of the contractor and already everyone has to pay the money. That is
The quantification you have done in your prayer portion, that is on the basis of those certificates.
Yes.
You have checked them.
Maybe now I am asking I need directors to pay that whatever it should be the certificate. Then I will.
Let us hear. Yes, yes, Mr. Bandhu. How have you dealt with these certificates?
But the lordship kindly take from firstly page 3 of my affidavit.
Yes.
When
Page 3.
these 3 paragraphs along with the
Yes. Yes.
kindly take page 3, paragraph 10. As deemed by the petitioner for the work executed in 2012, kindly mark the date. No work order or work completion certificate is attached with the petition. For the petitioner are claiming an amount of rupees 1,20,119 for the purported work done in 2012. Such claim is arguably barred by limitation and the date. So that part of the claim is barred by limitation. 2012, so that this petition is filed. After 10th of July 2023, 11 years. That the petitioner has failed till 11, but apprise this court that they have already received part payment from BMC authority to the tune of 7,40,000. That is rupees 5 lakhs on 2nd February 23 and 2,40,000 on 11 November 2022. So and so on, we have given the details at page 12. Thereafter, my lord, your lordship will kindly take paragraph 16 bottom at page 5.
Yes.
The last sentence. I say that an interim payment of 5 lakhs has already been made by the Vizianagaram Municipal Corporation on 2nd February 2023. Thereafter, your lordship will kindly take page 6, paragraph 19, last sentence.
Yes.
I say that the petitioner has so and so not annexed the alleged work completion certificate in support of his purported claim. This is pertaining to paragraph 6 of the writ petition, which is with regard to tender number 55/PWD/row. This they have pleaded that the work order has been given, but the completion certificate has not been attached. Thereafter, your losses will kindly take paragraph 20 bottom, which is at page 7. Last sentence, I say that the petitioner has not annexed the alleged work completion certificate in support of his purported claim. So this is with regard to paragraph 7, being work order number 191 PWD Road dated 9th of September 2022. So here, in these, no completion certificate is there. Thereafter, your lordship will kindly take
paragraph 21. From the middle, start the sentence starting after the one date is mentioned, 22nd November 2020. After that, after issuing the certificate, petitioner submitted his bill along with the CC, but till today payment has not been made. It is stated that the description of the work mentioned in the said writ petition does not match with the official records available with the Vidyanagar Municipal Corporation. I say that the description of work order number and the tender number does not match with the description of the work. It is further stated that the petitioner has so and so not annexed the actual work order. I say that an adequate payment of so and so has been made. So, Malad, 3-4 types of mismatches come. Issues come. One is, as mentioned, you claims are barred by limitation. Secondly, in some, work order has been annexed, but the completion certificate is not there. In some, the numbers are not matching at all. And Malad, in fact, I can there's a tabulation. This rate amount is a summation of what has been mentioned in paragraph 21 of the report. The logic kindly takes that.
Yes.
So, Malad, for example, this 94 by PWD BMC, this is the amount from which 5 lakhs was paid. This is the particular. Thereafter, Malad, the logic kindly take the second one.
So they are entitled to the rest. Regarding this, they are entitled to the rest. Your certificate, completion certificate.
But these completion certificates which have been given,
Yes.
they either do not match with the previous, or they do not match with the work order. But there is no admitted claim here. But what the job descriptions are sometimes different. I can even show one. If your logic kindly takes as an example, their own cluster of annex. Kindly Miller takes page 59.
59 years.
Well, this is a work order. Arising work order number, memo number 683 PW for estimate for new construction of Darin with RCPC cover around the RA playground within ward number 36. Then page 60 is another work order being serial number 1106 PW. But the completion certificate here also kindly take page 61.
Yes.
That is work order number 124 by PW. Of something, some other description of work. But there is no doubt that this petition is a regular contractor of the company. But these things, it has to be asserted somewhere. What they claim, merely putting all the eggs in the basket and then saying that I am entitled to so and so. This requires a trial of evidence.
Mr. Bandhavadhyay, at least regarding the certificates which they have annexed, you have taken a difference that you have paid fee 5 lakh plus 2 lakh 40. So apart from this 7 lakh 40, the rest of the completion certificate dues you have to pay.
But this is a composite claim being made. It is not a separate. I am not even going into the technicality. That separately it is all separate cause of action. Merely because the same petitioner, everything has been clubbed together. The divisions may be different. The work may be different. The timeline may be different. Everything, the prayer, it cannot be separated. And it is not their case that I am not pressing the 2012 claim. Everything at one go. I have put some 2021, some 2022.
2012 claim is only 1,20,000.
But it is there. It is part of that entire prayer.
That can be dissociated from it.
But that only one can be dissociated because it's a question is of limitation. But there are others where there is a mismatch. And these disputed questions cannot be gone into by your lordship sitting on it. I rely on a decision.
Yes.
But apart from what has been relied by my learned friend, you also have seen the order of the Honorable Single Judge put it. But the Honorable Single Judge directed payment. But that has been reversed. Actually, in effect, it has been reversed. Well, 2005, volume 12, Supreme Court case. 725.
Right.
Paragraph 7 and 9. 720. Please, paragraph 7.
Yes, yes, sir.
A bare perusal of the High Court judgment shows that there was clear non-application of mine. On one hand, the High Court observed that the disputed question cannot be gone into in a writ petition. It was also noted that the essence of the dispute was breach of contract. After coming to the above conclusion, the High Court should have dismissed the writ petition. Surprisingly, the High Court proceeded to examine the case solely on the writ petition assertion and on the very curious reasoning that though the appellate corporation claimed that the value of articles lifted were nearly 14.9 lakh, no details were specifically given. From the counter affidavit filed before the High Court, it is crystal clear that the relevant details disputing the claim of the writ petitioner were given. The value of the articles lifted by the writ petitioner is a disputed factual question, where a complicated questions of fact is involved and the matter requires thorough proof on factual aspect. The High Court should not entertain the writ petition. Whether or not the High Court should exercise jurisdiction under Article 56 would largely depend upon the nature of the dispute, and this dispute cannot be resolved without going into the factual controversy. The High Court should not entertain the writ petition. As noted above, the writ petition was primarily founded on allegations of breach of contract. Question whether the action of the opposite party in the writ petition amounted to breach of contractual obligation ultimately depends on the facts and would require material evidence to be scrutinized, and in such a case, writ jurisdiction should not be exercised. Then paragraph 9. In the instant case, the High Court has itself observed that the disputed questions of fact were resolved and yet went on to give directions as if it was adjudicating the money claim in a suit. The court is clearly informed. Thereafter, your lordship will kindly take 2011, volume 2, 64 cases 439. 2011 volume 2, 439, paragraph 8.
Yes.
The observations in HON'BLE related to a claim for refund of tax and have to be understood with reference to the nature of the claim in case. The decision in HON'BLE has been explained and distinguished in several subsequent cases, including so and so and so and so. Then can I take the subparagraph? Normally, a petition under 226 of the Constitution will not be entertained to impose a civil liability arising out of a breach of a contract or a tort to pay an amount. The aggrieved party will have to agitate the question in a civil suit. But an order for payment of money may be made in a writ proceeding in the enforcement of a statutory function of the state and government. But I am not multiplying my submission that this no way a statutory function will be discussed the implicit contract between two parties. If a right has been infringed, whether a fundamental right or statutory right, and the aggrieved party comes to the court for enforcement of the right, it will not be giving complete relief if the court merely declares the existence of such right to the fact that the existing right has been infringed. The High Court, while enforcing fundamental statutory rights, has the power to give consequential relief by ordering payment of money realized by the government without the authority of it. So, since it is being dealt from HON'BLE, if I realize some tax, some fee wrongly, then the reimbursement, they can come and claim. But this is not that. A petition for issue of writ of mandamus will not normally be entertained for the purpose of merely ordering a refund of money to the return of which the petitioner claims the right. The aggrieved party seeking refund to approach the civil court for claiming the amount, though the High Court has the power to pass appropriate orders in the exercise of the power conferred under 226 for the payment of money. There is a distinction between the cases where a claimant approaches the High Court seeking relief of obtaining only refund and those where refund is sought as a consequential relief after striking down the order of assessment, etc. While a petition praying for mere issue of writ of mandamus to the state to refund the money alleged to have been illegally collected is not ordinarily maintainable. If the allegation is that the assessment was without a jurisdiction and the taxes collected was without authority of law, therefore the respondent has no authority to retain the amount collected without any authority. The High Court has the power to direct refund in the petition. So there the distinction is drawn. Here the petitioner is in the top up before the order. They are merely claiming refund. They are not claiming reimbursement or refund of something that I have taken the money or tax fee I have collected from them illegally. It is one thing to say that the High Court has no power under Article 226 to issue a writ of mandamus for refund of the money illegally collected. It is yet another thing to say that such power can be exercised sparingly depending on the facts and circumstances of the case. For instance, where the facts are not in dispute, where the collection of money was without the authority of law, and there was no case of undue enrichment, there is no good reason to deny a relief to refund to the citizen. But even in cases where collection of cess, levy, or tax is held to be unconstitutional or invalid, refund is not an automatic consequence but may be refused on several grounds, depending on the facts and circumstances of the case. The summation is Roman 6, where the list has a public law character or involves a question arising out of the public law function on the part of the state or its authority. Access to justice by way of public law remedy under will not be denied. But here the relation is purely contractual. This public law remedy cannot be available to the petition. And lastly, the second last. So there's a old one. I am keeping the old one for the
I
last.
laughed at the second last. Yes.
I'm going chronologically backward.
Yes.
Well, 1994 supplementary to SCC, 466. Only one paragraph. Paragraph 2. We have no hesitation in allowing this appeal. The respondent had a money claim against the appellants. Instead of moving the appropriate court in a suit, they approached the Calcutta High Court under Article 226 of the Constitution. The writ petition attracted a counter from the appellant who raised a counter claim. Without adverting to the counter claim, the High Court went on to grant relief of payment of certain sums to the writ petitioner on the basis of certain suggested admissions by the appellant. The High Court then followed two separate courses, inasmuch as relegating the appellant to the remedy of suit insofar as the counterclaim is concerned, and ordering payment against the appellant insofar as the admissions made. This twin course appears to us to be wholly wrong. It does not appeal to us as to why a party has to go peacefully in a civil court, though it is appreciable that when a claim is admitted, a decree may be permissible to be passed under the CPC. But that too has to happen in a suit before an appropriate court of law. We thus are persuaded to straighten out things which have gone away, if not for anything else, at least for the sake of procedural and judicial discipline. Therefore, we allow this appeal set aside the issue not as such. So, it may so happen that I may have a counterclaim against the petitioner also. So, if the remedy is available to the petitioners here, then I am automatically relegated to the civil. When what they actually pray for is a judgment upon admission. The Supreme Court says that course is available to them under CPC also in a suit also. So they might as well can take that route in a suit also, saying that you are given compliance certificates, it's a judgment upon admission. And lastly, 1989, volume 2. 1989 to SCC 116. 21. 1989, 89, 116. Wait, this
Yes, sir.
this finding in our view is not correct in the light of the facts and circumstances of the case, because Ramana Jairam Shetty's case, there was no concluded contract as in this case. Even considering that the DGA has the trappings of a state or would be comprehended in other authority for the purpose of Article 12, while determining price of the houses or flats constructed by it and the rate of monthly installment to be paid, the authority or its agent after entering into the field of ordinary contract acts purely in the executive capacity. Thereafter, the relations are no longer governed by the constitutional provision, but by the legally valid contract, which determines the rights and obligations of the parties inter se. In this sphere, they can only claim rights conferred upon them by the contract in the absence of any statutory obligations on the part of the authority in the contractual field. There is a line of decisions where the contract entered into between the state and the persons agreed is non-statutory and purely contractual, and the rights are governed only by the terms of the contract. No writ or order can be issued under 26 of the Constitution to compel the authority to remedy a breach of contract, pure and simple. But what in effect they claim is that I have given you the work, you have not paid for me, paid to me. So it's basically claiming that part, that unpaid portion. That is a breach of contract. They cannot make out a case that you beyond the contract. Contract must have the trapping that you will do this work and I'll give you this payment. So, Malad, this purely is a breach of contract. It is a completely non-statutory contract. On the basis of it, they are making this claim. Malad, those are.
Yes.
My understanding, that for my land, like a number of judges. So money is actually it is not applicable because there is no physical record that is deviated or the contract has been violated. And not only that, I have not raised the bill. I have not submitted the bill. This is my bill. You should pay. It is their document. They have after taking the measurement, they send it, they prepare it, thereafter they issue the contract. That's why I have come. I know the way the distributed amount everything should be fine. But I can delay the amount their documents. There is no reason why they not paid on the basis of their documents. This is my one concern. And not only that, just so my language payment show that I have already disclosed each and every document. Page 67, tender number 24. All documents is there. After receipt, they have not raised any objection. No, we have not done this work. And you are not entitled to take the payment. Why do you have this people come people supposed to get the judgment from your lordship? Get more contact.
So they said that work orders are not, Mr. Bandhavate said that some of the work orders are not tallying with your completion certificate.
That's
Like, for example, he placed page 59.
what part?
59, 60 and 61. Just check up. Please check up. Compare 59 and 60 with 61.
59, this is what I have been added. Yes.
See the number of the work order reference or whatever. The work order memo number is there and the reference number is also there. So please tally this with page 61.
What order number? Similar my price.
The contract is here. The contract is also not here. But in some contracts, it requires the, for example, 2911 form. It requires the contractor to raise a bill within 7 days. Otherwise, the executing engineer will raise the bill. Each contract order is got in a different manner. What was their responsibility? What was our responsibility? These reciprocal obligations have to be gone into.
Actually,
But the moment you issue this certificate, now it's your certificate. After whatever you had to scrutinize, the certificate clearly gives that this is, suppose let us come to page 61, for example. Even if they don't give the work orders in the repetition, suppose let us proceed on that. Now you are saying that this is to certify that they have done the work, completed the work as below, and this is the final bill amount. After that, how can you resign from that?
But it does not say the final outstanding. For example, one document was shown by my learned friend. Our printed document is there. On the bottom left, some handwritten portions are there. Now, I ask this question about who has written it? Who has certified it? Is it the engineer? Is it the contractor? Is it a third party? But a document, if it is in written form, your lordship will disbelieve something finally written in hand. Merely by coming and saying, no, I have not suppressed, I have said 5 lakh has been received. Who has certified that? But these things have to be corroborated somewhere that this is the contract, this is the work order, this is the work done, I have done it within this specific period. But this is a completion certificate, is not the encyclopedia of the entire work. The measurement books are the measurement books are the content the details. Yes. That whether it was to be done in 6 weeks, whether they are done within 6 months.
Specifically mentions that the date of actual number.
Now the difficulty is that there can be an application under 226 with some prayer for mandamus, but there cannot be any counter mandamus that I can create. I cannot create this. There is no counter claim in retreat petition.
And that is another thing we have to be running account because they have specifically admitted under each account they have.
And I as one of the parties to the contract, I cannot file a writ against my learned friend. She contract on a state. So my remedy is in suit. Her remedy cannot be in 226. That is my sub.
Means does this CC at page 13, your petition page 13, para 21, this CC is as completion certificate.
Page 13.
13, para 21, that list of yours. Para 21, page 13. Page 13. Now there that third column head CC is completion certificate. No, this CC is completion certificate. Tender number, what order number, and CC. This is completion certificate.
Nothing is matching. Kindly see the relevant page is 25. The next entry is relevant page is 27.
No, 23, bro.
I have already done it
25.
4 times. How come now you can deny it?
I am denying from the pleadings itself.
Maybe reading there may be mistake on the
No,
part.
you have not accounted.
The variance between pleading and the annexures.
Yeah.
Client has accounted.
Kindly consider.
Please, thus, I am asking you a question. Please come to page 13, para 21.
Let us see.
CC's completion certificate. Now, your first annexure of CC is page 23. Please come to the date. That is 31st of August 2021. 31st of August 2021 does not find mention in any of in your list. So there is difference between variance between pleading and proof also. Now the next one is page 25, 18th of May 2030.
Amount is also not matching. Amount is not.
Date is not matching. How can the amount match?
You have also.
So I don't find
But
any.
next one, for example, page 27. Can you see? Amount is completely.
Let us go one by one. 25, page 25, 18th of May 2023. I don't find any mention because you have quantified your claim and you have sought to match that with which completion certificates you have not annexed. They are not telling you with your completion certificates even. No, Miss Das, I'm telling you. Page 23, this completion certificate does not find mention in para 21 of yours. Page 25, the next one does not find mention. That date is not there anywhere. So the first two I see, I do not find the dates in your list.
Third one is 27. And kindly see the
Third one is also not there.
kindly see the amount.
Date is not telling. How can the
No, amount gets added in the prayer. That is why amount is important.
dates are not telling? They have not even pleaded about
But
this.
that is why what my
When you have made the claims in your writ petition, none of the dates are tallying with your completion. None of them. And you expect the writ court to direct relief on that.
Maybe that will try to maybe mistake on my part because I
None of the certificates tally with your claim. What can be more patently perverse? You annex 10 purported certificates and in the list there are 10 certificates. None of the dates match. None of the quantum match. And you expect the writ court to grant relief on that on admitted basis. Act order. No, Miss Das. I really get you to us. Learned counsel for the petitioner contends that the petitioner did several works for the respondent authorities, that is the Bidhannagar Municipal Corporation. After the completion of such work, completion certificates were duly issued by the executive engineer, PWD, Bidhannagar Municipal Corporation. However,
and second, that is tender number 144, PWD such and such, 1.928. Yes, I have already distributed that. The tender number 144, 928, that is dated 4 April 2020. Now, Lordship's query on number, yes, this is the certificate. Only can you see this? That is the second point, second serial number 2. 144, tender number. I have already answered page 23. Page number 25. 144. Can you see this? And my claim is the final bill 1,49,000. Can you see this?
however, the respondent authorities are sitting tight over the matter. Next para. Learned counsel for the Bidhannagar Municipal Corporation by placing reliance on the affidavit in opposition filed in the form of a report, claims that the relief sought in the writ petition pertained to alleged breach of contract on the part of the Bidhannagar Municipal Corporation and ought to be the subject matter of a civil suit at best. It is contended that the claims are disputed by the Bidhannagar Municipal Corporation and, as such, the writ court ought not to grant relief, particularly since no public law element is involved. Push up, next para. It is contended that a part of the claim is time barred, pushed up by particular reference to the claim of rupees 1,20,119 made by the petitioner, it is pointed out that the said claim pertains to alleged dues of the year 2012, whereas the petition has been filed in the year 2023, about 11 years thereafter. Pushed up, next para. That apart, it is contended that at least two quanta of money to the tune of rupees 5 lakh and rupees 2.4 lakh have already been disbursed in favor of the petitioner, which has not been discussed in the disclosed in the writ petition. Pushed up, that apart, there is palpable discrepancy between the work orders and the completion certificates, as well as the pleadings in the writ petition. Full stop. Next para. Learned counsel for the Bidhanagar Municipal short form BMC. Learned counsel for the BMC cites the judgment of Odisha Agro Purana reported at 2005-12 SCC 725 in support of the proposition that where disputes revolve around questions of fact, the matter ought not to be entertained under Article 226 of the Constitution of India. First up, the best course of action would be to relegate the matter to a money suit. First up, in support of the same proposition, Learned Counsel also cites Godavari Sugar Mills, reported at 2011 to SCC 439, where the Supreme Court laid down several stipulations, including that normally a petition under Article 226 will not be entertained to enforce a civil liability arising out of a breach of a contract or tort to pay an amount of money due to the claimants. The proper remedy was a civil suit. The Supreme Court went on to observe that while enforcing fundamental or statutory rights, the High Court has the power to give consequential relief by ordering payment of money realized by government without authority of law. However, the Supreme Court made a distinction between money which was collected and a refund was sought in view of some erroneous assessment or legal consideration from an ordinary claim for refund of money. In the latter case, it was observed, the writ jurisdiction is used sparingly and a civil suit is the appropriate remedy. Learned Counsel next cites Eastern Coalfields such and such, reported at 1994, supply within bracket 2 SCC 466 for the proposition that if there was a claim and a counterclaim, the High Court acted without jurisdiction in segregating the claims to an admitted amount and to a disputed amount. It was observed that the entire claim would be decided in the civil suit to which the parties were relegated in the said case. Next para. Learned Counsel next relies on Berylli Development, reported at 1989 to SCC 116. In the said judgment, the Supreme Court distinguished between contracts which are non-statutory and purely contractual and those which are statutory. In respect of non-statutory contracts, the rights are governed only by the terms of the contract, and it was held that no writ or order under Article 226 of the Constitution can be issued. Next para. A perusal of the annexures to the writ petition indicates that certain purported completion certificates have been annexed by the petition, in particular at pages 23, 25, 27, 57, 61, 65, 67, and 70. Next para. It is, however, observed that there is discrepancy at least in respect of some of the said completion certificates with the associated work orders which have been annexed to the writ petition, although in some of the cases, the work order tallies with regard to the tender number with the completion certificate. Full stop, next para. That apart, comma, the claim made in the repetition is to the tune of rupees 65, 90, 449, which is based on a chart given by the petitioner in paragraph 21 at page 13-15 of the writ petition. Full stop. A perusal of the claim, perusal of the quanta of claims with the corroborating completion certificates given there shows palpably that most of the dates of the completion certificates given in the said chart, which is the sole basis of the claim, do not tally at all with the annexures to the writ petition. Full stop. In fact, the court perused the first few completion certificate dates, corresponding to which no annexure is found in the writ petition at all. Full stop. Next paragraph. Thus, although the petitioner relies on purported completion certificates, there is utter variance between pleading and proof, which even as per the corresponding concepts in the Code of Civil Procedure, do not entitle the plaintiff to a relief, to a monetary relief. Full stop. Next para. In any event, since the claims are disputed squarely by the respondents, a calculation and a detailed evidence taking procedure is required to be gone into before deciding conclusively whether the claims of the petitioner are valid. Full stop. Moreover, to substantiate the claims, the petitioner is also required to tally the corresponding work orders with the completion certificates, which again has to be in consonance with the pleadings made in the claim. Full stop. Next para. Thirdly, the petitioner is also required to prove the veracity of the documents in due process of law as envisaged in the Code of Civil Procedure and the Evidence Act for the court to grant a monetary relief to the petitioner on the basis of such documents, particularly since the veracity of some of the documents have been controverted by the respondents. Next para. Keeping in view the ratio laid down in the judgments cited by the respondent, this court is of the opinion that in the present case, there is no clear-cut admitted claim for the court to direct the respondents to disburse the amounts claimed by the petitioner. Even if the court could have been lenient inasmuch as the work done by the petitioner pertains to public work, which has an iota of public law element, in the circumstances as indicated above, it would be a dangerous precedent to grant the relief as sought in the petition, in an application under Article 226 of the Constitution of India without going into a fact-finding endeavor upon adduction of proper evidence in due course of law. In such view of the matter, WPA 16.357/2023 is dismissed without any orders to cost. However, nothing in this order shall preclude the petitioner from instituting a proper suit before a competent civil court, subject, of course, to the law of limitation. If such a suit is filed, the civil court shall decide such issue in accordance with law without being influenced on merits by any of the observations made here. No orders to cost.
But the documents are confidential. But the rates of the documents are not confidential.
Whatever is.
Just now you are talking about that each that I have subjects. It's not that the subjects I have disclosed. I have come in and letting it add something.
No, whatever order passes.
So this is
Yes.
coordinate with also interview this application.
Yes, present.
More or less this matter in it. Just now the lordship was reading this matter.
No, this is different. There are admissions here.
Well, let's say it is on the same line. But
Apart from your admission,
I was hearing this.
I'll look at your admission. No, but the petitioner is not there. How should I? Why should
No, I'm not being, I'm just saying, no, I was given a directive to file petition. Can you keep it after petition or not?
You are given a fortnight stay. Are you ready with the affidavit?
Yeah, the affidavit is ready, but person who will affirm it is ready.
None appears for the petitioner at the time of call. Full Learned counsel for the state seeks an extension of the time for filing affidavit in opposition. Full Accordingly, the time for filing affidavit in opposition is extended till January 5, 2024. Reply finish shall be filed by January 12, 2024. The matter shall be listed on January 15, 2024 for hearing under the usual way. Upgraded থাকবে না petitioner. Write legibly, it will be depicted properly.
21.
Yes.
Reading this. Here is for removal of defective meter. This is total of reading straight. Petitioner is a old lady widow staying alone in her house. Initially, my lord, the fee was raised up 5/4/2021, 2004. Immediately after 5/4/2001, the fee was raised three times. And thereafter, I made objection
3 times for the same period? Or 3 times?
3 times.
Very good.
Your lordship, I kindly have you page 16.
Yes.
Page 16 is briefs, the 2463. And your lordship, I kindly have you page 18.
Yes.
That is 5,000 and what?
So this is a billing dispute.
No, it's I am not. And hereafter,
Yes.
I made an application because of the feature is 30. Your lordship, I kindly have you. That is a page. And thereafter, they have not in accordance with law.
When did you apply for change of the meter?
That is at page 26.
What is the date?
12/8/2021. Lord, I am informing that I suppose there is some fault in the meter. This is my allegation.
Yes. We'll continue. Don't do that, master. Do this time. Tell the division bench I have to.
21.
Yes. So this is not a billing dispute, you are saying. Why not? You alleged that the meter was defective.
Meter is defective.
Right.
The complaint is, that is at page 26.
26.
I specifically say that the high rate, I am informing you that the for few months the charges of electricity bill is coming at a high rate, which is out of my imagination. I suppose there is some fault in the meter number so and so. Everything is therefore I request you to kind arrange a check meter as early as possible. That prayer was made on 12/8/2021. The rule says, in case the rule is the regulations will be called the West Bengal Electricity Regulatory Commission Standard of Performance of License relating to consumer services.
This is regulation number?
Regulation number 46 WREC.
Yes. What is that? Which clause?
Rule 11.1. The replacement of bulb out and other faulty meters, slope metering system where supply is not affected. Yes, supply is not affected. But what is the? In urban areas, the meter shall be inspected 3 days from the date of receipt of the complaint. I have a page. I have quoted the entire thing. That is page 8.
Page?
Page 8.
Yes.
The replacement of bulb out and other faulty meters metering system where supply is not affected. In urban areas, the meter shall be inspected within 3 months from the date of receipt of the complaint. The date of receipt of complaint is the 12/8/2021. Within 3 days, they have got inspected. What I have done thereafter, once again, 3/11/2021, I have made another representation.
Yes.
And thereafter, in the month of 2000, in the year of 2022, they have installed a check meter.
Which month?
Date is
No, which month you say?
11 February 2022. Check meter was installed.
Yes.
Page 28.
Right.
Check meter shows that the original meter is defective. Despite that, meter has not been replaced, and they are placing the bill in 3 months, 33,000, 15,000, 20,000 in 3 months. Beyond your imagination.
Where is it shown to be defective?
Where
Where is it shown to be defective?
Page 28.
I don't find anything regarding defective.
I will show you. I'll show you. Page 28, 11/2/2022.
Yes.
The original main meter. Reading was 8478, and on 5/4/2022, reading was 8807. Units consumed were 370 units. Minus the 8807, 8807 minus 8478, 370. And what your lordship made? Next line. Check meter. That is check meter number, right side column number 2857,245. This is check meter number 1, and thereafter bottom L4032825. That is second check meter. 2 check meters are installed. What check meter shows there? On 11/2/22, it shows unit shows in the check meter 5139, and on 5/4/2022, the original meter shows 8807. The check meter shows 5310. So 5310 minus 5139 is equal to 171 units. And second check meter shows that units consume 170. 5914 minus 5744 is equal to 170. So now 2 check meter shows that 170 units and 170 units were consumed. But the original meter shows 370 units consumed. Accordingly, automatically it can be derived that original meter is defective. And what 33,000.
Even after that, they have not replaced.
Hereafter, various representations having no other alternative
Not replaced.
No replaced. They're facing the bills month after month, and last before mentioning the disconnection people have come and threatened that if the interim order is obtained, if not obtained, and disconnect the electricity connection. And when my liability comes after the, I have fulfilled all my liabilities. And they have the proper statutory guidelines that are on their.
Yes, what do you say?
But so far, the regulation which has been cited by my learned friend is not at all applicable in the context of the instance. The supplies has been effective. It is not that here it has been specified where the supply has not been effective. My learned friend is enjoying electricity till date. So they haven't never disconnected the line. What happened, Your Lordship? They have made an application that there is a case of
Why do you say supply has not been affected? It is not said there. Please come to page 8, the clauses. The writ petition itself. Page 8 of the writ petition. They have quoted.
replacement of burnt out and other faulty meter system where supply is not effective.
Affected.
Affected.
Not affected, affected.
Affected.
Supply affected means supply may not be. Yes, in those cases only this provision applies.
But there is a specific provision under regulation 55 I will show relating to the defective meter.
Here the supply is not affected, so this applies.
The electricity is still electricity. Electric connection is there.
That is where this applies. It said replacement of faulty meters
Yes,
where supply is not affected. Then this has to be done.
Well, what she working upon in case the meter system is found otherwise faulty, the meter shall be tested and same shall be replaced within 10 working days from the date of inspection. But this is what happened where there is a case of a defective meter. As per regulation 3.6.1, I will show to you, Lordship. That is the regulation 2013.
They complained first on 12th of August 2021.
Lordship,
and you checked up for the first 15th of April.
We have already done, and we have. I am saying what has been specific. I am saying now. After that, we have issued a check meter. Now, by virtue of the check meter, we have found that the meter is defective, and certainly the bill which has been raised, we have said that it's for corrections, and the corrected bill has been given to them. And thereafter, Your Lordship knows that there is in case of a defective bill, we can lay the average bill consumption because the connection is still in existence. They are enjoying the electricity. And on that basis, we have stated that there are certain outstanding due. You pay that amount, we will replace that bill. But instead of doing
Why should they pay them? Why should they? You are not replacing the meter and you are going on average billing.
Average billing, we have made up to Lordship kindly see. But we never disconnected that. Still they are enjoying the electricity.
But you are asking for this amount, why should they pay that? After 10 days, Mr. Dr. Shaharai, after 10 working days, your time was up. You had to do it.
Time come to regulation 55. I'm drawing a lot of kind attention to regulation 55.
Regulation Yes.
Five. That is August 2013. Lordship, what that?
Yes. Which clause?
First, I'm drawing your Lordship attention to payment of disputed bill 3.5, but I'm not going into that. First of all, Lordship kindly come to 3.6. 3.6.
Yes.
Billing for consumption of electricity in case of defective or infirmity. Admittedly, according to him, that it is a defective meter. And when we have detected that this is a defective meter, we have issued an average bill on the material. Lordship kindly see here it has been said if it is not for unauthorized use of electricity, admittedly it is not unauthorized use of electricity. It's a consumption of electricity. And on that basis that we have raised an average consumption of bill. And we have issued the bill and we have requested him to make payment for that. Instead of making payment, he has paid the part payment. But thereafter, he has not made the payment. And we have said that if you make this payment, we will issue the we will replace the meter. But instead of doing that, he has made a part payment and he is enjoying the electricity and he never paid the extra. So my humble submission is that let them pay the amount which is outstanding due at present. And thereafter we will
No, but Dr. Shara, you cannot continue indefinitely with a defective meter after seeing that it is defective
no,
and claim average bills.
well, we have, if it is seen to be the defective meter, we have raised that average bill for the time being as per the regulation. It's not that out of the statute we have raised the bill, but instead of making payment, he sat tight over the matter. Now,
Dr. Shara, this has to be read in conjunction with clause 11. You have a duty under clause 11.1
no,
to replace it. No, to replace it within 10 days. If you have not done that, why should they go on paying average billing?
We have to pay that the average bill first of all 3 months they have to pay that.
For non supply of rectified meter, you should then pay them compensation.
First, kindly see 3.6 for a moment. Yes, they are placing. If on inspection by the is on a phone on the basis of a complaint of a consumer, the meter of a consumer is found to be defective or defunct for a reason other than theft of electricity provided under such and such, and no theft of energy can be suspected, the consumer shall pay provisionally for such consumption of electricity. What has been consumed? Consumption for the period during which the meter has been suspected to be defective or defunct on the basis of average consumption, and other parameters for the preceding, succeeding 3 months or during any previous and or subsequent period that may be reasonable comparable before the meter has been found to be defective. So my humble submission before Lordship, on that basis we have raised the bill, but instead of making payment, they are enjoying the, let them pay that bill, that part. But first criteria here, he could have come and saying that I have paid that bill.
Why didn't you replace the meter?
But this payment has not been made. The average bill has.
Why didn't you replace the meter? That has no nexus with this. They complained in 12th of August 21.
But we have made
And the first check meter was installed on 15th of April 2022. You merely go on not replacing it and you claim average bills. He could have paid much less probably. How do you know what would be the real rate?
But that is the rate we can, because it's a system generated bill. And in the system generated bill,
you are not understanding the issue, Mr.
No,
Dr. The issue is very specific. They complained on 12th of August 2021. Within 10 days, you had to replace the meter if it was defective. But you installed the check meter for the first time on 5th of April next year. After say 4+4. Yes. 11th of February 2022. Which is after 6 months. Yes, what do you say to this? You have to pay the average bills. I'll dispose of you pay the average bills, they replace within a week.
Subject to sanction, that is page 17 up to 5th April 2021. The bill rate 2000 and all. And thereafter the fixed 2000 and all. And thereafter after 5th April the next page. And before that 2000, 1030. All of a sudden on 5th April 5068 I have paid this bill. This is the abnormal bill, although I have paid. And thereafter, the very next page, page 19, up to 4/10/2021. Bill is 5,424. Bill amount is. I have paid this bill.
So even after writing to them, they have been charging on the basis of the faulty meter.
Yes.
When was the average bill set?
No average bill was set.
We have said that.
When?
No average bill was set. See, I'm showing you your lordship.
Very well, I'll give you liberty
This
to.
is not subsequent bill.
I'll give you liberty to. They'll.
Page 19. Page 19 is the subsequent bill. After
I'll give you liberty to approach the grievance redressal officer regarding the billing the entire period after you informed him. That will be decided by him afresh in terms of these relevant clauses 3.6.1. One. Secondly, they'll replace the meter within a week from date. Thirdly, I'll put in a rider that until it is decided by the grievance redressal officer, they'll not disconnect him for this period. The disputed period, you don't have to pay for the time unless it is decided by the Learned counsel for the petitioner argues that the petitioner's electricity bill was reading exorbitant rates. Pushed up next para. Although the petitioner wrote to the to the distribution licensee on August 12, 2021 for the first time, and then on November 3, 2021 for the second time, comma, no check meter was installed until April 5, 2022. Pushed up, I'm sorry, until February 11, 2022. Pushed up next para, it is submitted that in the meantime, comma, no replacement was also made regarding the meter. Sub-learned counsel places reliance on clauses 11.0 and 11.1 of regulation 46 of the WBERC, which stipulates that in case the metering system is found otherwise faulty, comma, the same shall be tested and shall be replaced stroke rectified within 10 working days from the date of inspection. First up, in the present case, comma, it is argued that it was the incumbent duty of the WBACTCL to hold an inspection immediately after the petitioner brought to the notice of the WBACTCL about the faulty meter readings, comma, which was not done. First up, unfortunately, comma, it is argued that subsequently the WBACTCL went on charging at such exorbitant rates on the basis of the faulty meter, comma, without replacing or repairing the same. Push up next para. Learned counsel appearing for the WBACTCL submits that as per regulation 55, comma, clause 3.6.1, comma, the licensee has a right of average billing on the basis of the stipulation as made therein. Full It is submitted that the WBACTCL in the present case had made such average billing in terms of the said clause, and as such, comma, the petitioner ought to have paid the said amounts. Full next para. Insofar as the replacement is concerned, comma, it is submitted that the WBACTCL is agreeable to replace the meter. Full next para. A perusal of the materials annexed to the writ petition indicates clearly that the WBACTCL, comma, instead of average billing in terms of clause 3.6.1 of regulation 55, comma, went on billing at exorbitant rates, comma, on apparently exorbitant rates, comma, on the premise of the readings rendered by the faulty meter. Full stop. The petitioner is justified in arguing that as per clause 11.1 of regulation 46, comma, it was the bounden duty of the WBACTCL to hold an inspection and change the meter within 10 days from the complaint being made, that is on August 12, 2021. Full stop. Having not done so, comma, the WBACTCL palpably acted without jurisdiction in going on overcharging the petitioner on the basis of the faulty bills. Full stop. Next para. Thus, comma, however, comma, this court is not in a position, comma, not being the first authority under the regulations, comma, to decide as to what would be the actual electricity charges payable by the petitioner in terms of clause 3.6.1. Full stop. Next para. In such view of the matter, comma, WPA 19609 of 2023 is disposed of by directing the WBACTCL to replace the defective meter of the petitioner within a week from date. Full stop. Next para. The petitioner is given the liberty to approach the concerned grievance redressal officer having territorial jurisdiction, comma, also within a week from now, comma, with the dispute regarding the alleged excessive billing of electricity charges from August 12, 2021 onwards. Full stop. Next para. Upon such approach being made, the grievance redressal officer shall decide the same in accordance with law. Upon hearing all concerned, as expeditiously as possible, positively within January 31, 2024. Full stop. Next para. However, the WBACDCL shall remain restrained from taking any coercive action against the petitioner for non-payment of the arrear bills for the period after August 12, 2021 till the replacement of meter is made by the WBACDCL, until the matter is finally resolved by the grievance redressal officer. Full stop. However, the above order shall be conditional upon the petitioner going on paying the regular electricity charges upon the faulty meter being replaced by the WBACDCL. Full stop. No less to cost.
Question not shared as to whether you are family pensioner able to a widow of the employee who retired, but thereafter used to get the pension. And thereafter the widow applied to the government. The government directed yes, family pension. Whether the statement can say that no, this amount is not responsible because certain rules amount in respect of the pension was existing and you have to either adjust it or pay. One will try and look at first page number 2.
Yes.
This is Central Salt and Marine Chemicals Research Institute, Bhavna. You'll also see, it is hereby notified that Dr. Shomit Kumar Odhi, ex-scientist, and pensioner of this institute, has expired on 24th May 2023 as per the death certificate. In accordance with the provisions contained in Rule 50 of CCS Pension Rules 2021, the competent authority has been pleased to sanction the payment of pension to Mrs. Shwapna Odhikari, wife of late Dr. Shomit Kumar Odhikari, which has been from 20 May 2023 till her date on the marriage. Mrs. Shwapna Odhikari is also entitled to draw the undisbursed portion of pension and any other dues of her late husband, Dr. S.K. Odhikari. But from the prior to that, we can look at one letter of the State Bank, 1/7/2023 at page 18. At page 18. With reference to your family pension proposal, O/A, let Shomit Kumar Odhikari. This is to inform you that 2 active pension law are present under the pension bearing account number, etc. Current outstanding rupees 86,211 and account number, etc. Current outstanding 8,39,435. In order to start family pension, it is important that you are requested to either close both the loans or close at least one loan with undertaking to continue the existing loan maximum 1 loan so that we can proceed for family pension. So this is according to our evaluation commission, not tenable in the eyes. Now we will try to look at their another letter at page 31. They are little bit modified. 26th July 2000. You are requested to Shwapna Odhikari. They are writing to Shwapna Odhikari. 7 years. You are requested to either close the existing pension accounts immediately or submit us the undertaking for repayment of existing pension loan installments after commencement of family. You are also requested to deposit an amount of 19,961, which was withdrawn from pension account after demise of petitioner Dr. Odhikari to enable us to make final settlement of original pension account before commitment. Now, Malan has seen from the order of the government that I am not only entitled to family pension, but also undisbursed portion of the pension account of my husband. Now, I will kindly look at your lordship knows section 61 sub G to be CPC.
Yes.
Which things cannot be attached? Section 60, where I first read,
The following property is liable to attachment and sale in execution of a decree, etc., provided that the following particulars shall not be liable to such attachment or sale, namely, I kindly come to G. Stipends and gratuities allowance to pensioners of the government or of a local authority or of any other employer or payable out of any service pension, family pension fund, notified in the official gazette by the central government or the state government in its behalf and political pensions. Now, I will look at once whether your also I do not know whether this will be also relevant because the pension at 1871 in section 11 what says section 11 is at 672 page number 607.
Yes.
No pension granted or continued by government or political considerations or on account of past services or present infirmities or as a commission of compassionate allowance and no money due or to become due on account of such pension or allowance have been liable to seizure attachment by sequestration by process of any court at the instance of a creditor or any demand against the pensioner or in satisfaction of a decree or order in such. One will look at one of the judgment which I have now. Excuse me for marking. 2009 volume 1 SCC 376. Radhesham Gupta versus Punjab. I will only refer to para 31 and 32. Sorry, 33 and possibly 35. 1 minute. 33 and yes, 33 is at page 384.
Yes.
However, we are also of the view that having regard to proviso G to section 60 bracket 1 of the code, the High Court committed a jurisdictional error in directing that a portion of the decretal amount be satisfied from the fixed deposit receipts of the appellant held by the bank. The High Court also erred in placing the onus on the appellant to produce the material in question for being auctioned for recovery of the decretal. In other words, the High Court are in altering the decree of the trial court in its divisional jurisdiction, particularly when the pension and gratuity of the appellant which have been converted into fixed deposits could not be altered, attached under the provisions of the court. The decision in Jyoti cheat fund earlier in this case will be sought to be decided. In page number, paragraph number 23, you will actually get it. Sought to be decided that no pension till the time of the payability, it could not be added. But once it comes to the account of the person, it can be added. But that decision not accepted. The decisions in Jyoti cheat fund case has been considerably watered down by later decisions which have been indicated in para 22. But I will show para 22 and 23. And it has been held that gratuity payable would not be liable to attachment for satisfaction of the court decree in view of proviso G to section 60 bracket 1 of the code. But can I look at paragraph 35?
Yes.
We also agree with Shobha, MS Shobha, that and advocate that even after the retirement benefits such as pension and gratuity had been received by the appellant, they did not lose their character and continue to be covered by proviso G to section 61 of the code, except the decision in Jyoti cheat fund and finance case where a contrary view was taken. The consistent view taken thereafter supports the contention that merely because of the fact that gratuity and pensionary benefits had been received by the appellant in cash, it will no longer be identified as such retirement benefits paid to the appellant. But we look at in this connection, para 22 and 23. Page number is 382.
Yes.
Para 22. MS Shobha's submission finds support in the decision of this court in Calcutta Dock Labor Board versus Sondha Mitro, where it was reaffirmed that gratuity payable to dock workers under the scheme in absence of a notification under Section 5 of the Provision of Gratuity Act would not be liable to attachment or satisfaction of the court's date. The same principle was reiterated by the court in Union of India Supreme Commander and Gorakhpur University. Well, we can now look to prayer, which will make everything clear. However, in all fairness, M.S. Shobha also cited the decision of this court in Union of India versus Jyoti Chitfund, where while dealing with the provisions of Section 3 and 4 of the Provident Fund Act 1925, prohibiting attachment of sums said by the government, as well as Provision G to Section 61 of the code, this court held that till such time as amounts payable by way of Provident Fund, compulsory deposits and pensionary benefits did not reach the hands of the employee. They retained their character as such and did not therefore be paid. However, once the amounts were received by the employee, they ceased to retain their original character and were therefore capable of being attached. M.S. Shobha urged that the aforesaid decision had been rendered long before the other decisions cited by her, and the subsequent decisions would prevail over the other decisions. But what I am submitting to that, this is a family pension. A lady, 67 years old, has to get until her death and of the marriage. At this stage, it is possibly not for her to go for remarriage or anything. But in this situation, that family pension to be paid, what statement is saying? I'm praying for particularly, the prayer B. Also, can you look at once? Prayer B. Each of are already the nature of mandamus directing the respondents, particularly the school number 1 and 2, to disburse family pension to the petitioner unconditionally and without any fees. I think
Yes.
First of all, section 60, section 11, section 60 of the CPC, section 11 are not applicable in this matter. These are with regard to attachment and decree. Where court has passed the decree, whether that decree can be, whether the family pension can be attached for enforcing the decree or not. That has been raised in these sections, in this provision. But here the case is that the husband of the petition, he took loan from that account, pension account. Loan from the pension account. Now, after the death of the husband, the petitioner wants a family pension. That very account to be argued. Obviously, she is entitled. I am not on that. But if she is entitled to that account, she should also take the responsibility of making the payments of the EMI or taking the responsibility. So it is not a case of decretal amount. It is completely a different thing. Loan was obtained from that pension account by the husband of the petition. This is husband of the petition. Now he died. The loan is not yet recovered. The outstanding is still there. Huge amount of outstanding is still there. So it was just after the petition. You give the EMI. You continue with the EMI. We start your family pension scheme. You are entitled, obviously. Since your husband died, you are entitled. But this has to be done because who will pay my loan? Then this loan account automatically nobody will be able to pay the account. She is refusing. She said, no, I will not pay a single. I do not know what my husband has taken. I am not concerned about that. I will not pay a single penny. You just start my family pension. Because family pension is not a question of attachment by any decree. Because the same account, the same pension account, and he is having a loan with it. So the loan is to be paid. But since she had not paid, the account has become NPA on 31st October 2023. And outstanding, there are two accounts made, two loan accounts out of this. One account outstanding is 8 lakhs, 70,000, more than 8 lakhs, 70,000 as on date. I have taken instructions. And another account that I was software from mobile, Insta from mobile. The due is about 86,000. So my lord, about 9 lakh
or more, something a little more. It's a total deal. Now, if the family pension starts, my lord, she will be getting a sum of rupees 54,000. And the EMI that she is supposed to pay is about 23,000. Apart from the already outstanding, the area which are still required to be paid.
EMI regarding the loans.
Regarding loan. That has to be undertaken. We cannot say that I will eat the fruits and I will not bear the pains.
Good. Yes, what
I
is
agree with that.
yes.
Well, this correction will not possibly will not leave on my line. Kindly look at verse 650 of this. Who is the legal representative? How the money to be recovered is placed. Where is judgment dies before the decree has been fully satisfied. The holder of the decree may apply to the court to pass a state to explain the same eventually. I'm saying from these are the general conceptions. How a particular loan or whatever money left by the deceased, where the decree is executed against such legal representative, he shall be liable only to the extent of the property of the deceased which has come to his hands and has not been duly disposed of. And for the purpose of ascertaining such liability, the court executing the decree may, of its own motion or on the application of the decree holder, compel such to produce such accounts as it is fit. So, my lord, whatever amount would be coming to me on my husband's date, other than the family pension, I am liable to get it as well. They have talked about NP. Well, NPA, as far as my knowledge is, NPA is a thing which has been started after the 2002 the acts in non-performing assets. If it is a non-performing asset, the court will declare, that is the authority will decide whether it is NPA or not. That authority will seeking for execution will call me and I will be bound to produce the accounts. These are cannot be said that for that reason family pension will be. I think these are
No, but the difficulty is in your case, here it is not a different claim that the bank is making and trying to attach your property, attach your pension. The loan was taken precisely from this pension loan account. So if the loan was taken from the pension account, don't you have a liability to meet that first?
I'm asking the question to myself.
Yes, yes.
This is to be proved by the bank.
You are inheriting through your husband. Your entire claim of family pension is due to the demise of your husband. So if your husband himself took the loan, you cannot, as you said, you cannot take the fruit and leave aside the.
No, I'm grateful to your Lordship, and you said what if. Well, that if, but I have never said that that particular loan is lost. Number one. Number two, that the bank has to do. But according to the law, Rima is submission, Rima will decide. According to the law, family pension possibly cannot be enforced. And I am the legal representative in respect of the news of the things. I will be producing all the details of the properties, whatever I have got. Why not knows that so far the properties are concerned. Whatever property I have got from my deceased, from the deceased husband, those are liable to be arrested, not my independent property. Family pension is an independent property, independent thing. It's payable to me by the government. This possibly is not in terms of section 50 of the because this is not the property belonging to my husband. These are the things.
The petitioner is the deceased widow of one Dr. Shomir Kumar Odhikari, who was an employee with the CSIR-Central Salt and Marine Chemicals Research Institute, Bhavnagar. Pushta, the said employer of the deceased husband of the petitioner, on the demise of the husband on May 24, 2023, by an office memorandum dated August 7, 2023, notified that upon the demise of the petitioner's husband, as per Rule 50 of CCS within bracket close rules, 2021, it was decided by the competent authority to sanction payment of family pension to the petitioner with effect from May 25, 2023 till her death or remarriage, whichever is earlier. Full stop. Prior thereto, on July 1, 2023 and on July 25, 2023, by two separate communications, the respondent bank had intimated the petitioner that with reference to the family pension proposal, two active pension loans are present under the pension bearing account bearing number 415537689909 within bracket current outstanding rupees 86,211 and account number 40438762918 bracket current outstanding rupees 8,39,435. Full stop. In order to start family pension, it was intimated by the bank to the petitioner that the petitioner was to either close both loans or close at least one loan with undertaking to continue the existing loan within bracket maximum one loan bracket close so that the bank can proceed for family pension proposal. Full stop. Learned counsel assails the bank's action of withholding the family pension to the petitioner on the ground that even under the analogy of section 60 of the Code of Civil Procedure, stipends and gratuities allowed to pensioners of the government or payable out of any service family pension fund notified in the official gazette by the central government or the state government shall not be liable to attachment or sale even in execution of a decree. Full stop. Learned counsel places section 50 of the Code of Civil Procedure, full stop, subsection 2 of the same provides that where the decree is executed against the legal representative of a judgment debtor, when the judgment debtor dies before a decree has been fully satisfied, he shall be liable only to the extent of the property of the deceased which has come to his hands and has not been duly disposed of. Full stop. Next paragraph. By drawing a line of distinction between the property of the deceased husband and the petitioner's own entitlement, it is argued that family pension is given, although on the demise of the husband of the petitioner, to the petitioner in her independent right as a widow of the petitioner and has no nexus with the inherited property of her husband. Full stop. Learned counsel places reliance on section 11 of the Pensions Act 1871, which also provides that no pension granted or continued by government on political considerations or on account of past services or present infirmities or as a compassionate allowance, and no money due or to become due on account of such pension or allowance shall be liable to seizure, attachment or sequestration, SEQUESTRATIO, by process of any court at the instance of a creditor. Full stop. Next paragraph. Learned counsel places reliance on a judgment of the Supreme Court rendered in Radheshyam Gupta versus PNB and another, reported at 2009 1 SCC 376, where the Supreme Court observed, inter alia, that the High Court erred in altering the decree of the trial court, particularly when the pension and gratuity of the appellant, which had been converted into fixed deposits, would not be attached under the provisions of the Code of Civil Procedure. It was observed that the decision in Jyoti Chit Fund case has been considerably watered down by later decisions which have been indicated in paragraph number 22 of the cited judgment, and it had been held that gratuity payable would not be liable to attachment for satisfaction of a court decree in view of proviso small g to section 60 within bracket 1 of the code. Full stop. It was also observed that even after the retirement benefits such as pension and gratuity had been received by the appellant, they did not lose their character and continued to be covered by proviso small g to section 60 within bracket 1. Full stop. Next para. It is thus argued that even if the bank alleges that the petitioner's husband had outstanding dues by way of loan taken from the pension account, the bank cannot assert its rights on the family pension payable to the petitioner on such count. Full stop. In any event, it is contended by the petitioner that the petitioner disputes the outstanding dues as alleged by the bank. Next paragraph. Learned counsel for the respondent bank contends that the provisions of section 60 are not applicable in the present case, since the instant matter does not pertain to the claims of the bank on the basis of decretal dues. This is not a case of attachment, but the husband of the petitioner himself had taken a loan not from any other account but from the pension account itself. As such, if the petitioner claims the benefit of the said pension, it is the incumbent duty of the petitioner first to meet the liabilities of the said account with the bank. Next para. Over and above, it is argued that the pension account has been marked as non-performing asset within bracket NPA in terms of the concerned guidelines of the Reserve Bank of India in the meantime for non-payment of the loans. Next para. Thus, it is argued that the ratio relied on by the petitioner is not applicable to the present case, and the bank is entitled to withhold the family pension on the ground of the petitioner having not cleared off the loans taken by her husband from the same account. Next paragraph. The point which has arisen for adjudication here is whether the family pension is a component of the estate which the petitioner derives by way of inheritance from her husband. Next paragraph. The governing jurisprudence in the field of pension and gratuity as well as family pension is clear on the issue. Family pension is not a part of the estate of the husband, of the deceased husband, stroke predecessor in interest of the person who is entitled to the said pension. Family pension is a sort of subsistence provided to the heir of the deceased in view of the financial crisis suffered by such heir on the demise of the original employer. The said pension is for the upkeep and maintenance of the heir and not a component of the estate of the deceased employee. Although the right to get such a pension accrues on the demise of the predecessor in interest, the family pension is an independent component of gratuity paid to the petitioner and not a part and parcel of the estate of the deceased, which devolves on the heir upon such demise. As such, the argument that the petitioner is required to meet the loans of the husband of the petitioner prior to getting the benefit of the estate is not applicable to the concept of family pension. Next paragraph. As to the other aspect of the matter, that is the bank's dues in lieu of loan taken by the deceased husband, allegedly from the pension account, if the bank is of the opinion that the said account has been marked as NPA and there is an outstanding due in that regard, the bank has every option to recover the amount and or to take appropriate steps in accordance with law in that regard. However, before obtaining a decree stroke award stroke taking appropriate measures under the governing statutes, the bank cannot claim a lien over the future family pension which is to be disbursed in favor of the petitioner. Even assuming that the husband of the petitioner took a loan from the pension account which could not be serviced during his lifetime, comma, it still remains that the bank has to obtain a recovery of such amount in due process of law. Full stop. No provision of law or jural concept in India entitles the bank to have a lien on future family pension to be paid to the heir of the deceased with regard to a pre-existing loan taken by the predecessor in interest during his lifetime. Full stop. As such, comma, the action of the bank in withholding the family pension to the petitioner on the ground that her husband has left outstanding dues with regard to the loan account, comma, albeit the same pension account, comma, is not tenable in the eye of law. Full stop. Next para. As rightly argued by the petitioner, comma, the principle of section 60 is applicable to the present case, although not directly, but on point of analogy. Full stop. Section 60 is of a higher right where a decree holder has the benefit of a decree and seeks to implement the same on a particular property. Full stop. Section 60 of the Code of Civil Procedure exempts family pension and gratuity, etc. even on such count, comma, where the decree holder has a valid and legitimate decree in his favor, which can be implemented in law. Full stop. Next para. Section 50, comma, as rightly pointed out by the petitioner, comma, of the Code of Civil Procedure, does not entitle the bank to withhold family pension, comma, which, as discussed earlier, is not a component of the estate of the deceased. Full stop. Thus, comma, the bank cannot go one step further than contemplated in section 60, which is with regard to attachment of a property in execution of a decree, comma, before having a proper award or decree and or having taken steps under the due provisions of law for recovery of the amount. Full stop. Next para. In view of the above observations, comma, the bank acted without jurisdiction and authority in withholding the family pension of the petitioner on account of previous loans allegedly taken by the petitioner's husband. Full stop. In the event the bank is of the opinion that there were such outstanding loans, comma, the bank is required to make a claim in due process of law from the petitioner, comma, giving a right and opportunity of representations to hearing to the petitioner, and only thereafter can take due steps in accordance with law in that regard. Full stop. The modus operandi adopted by the bank in the present case, comma, however, comma, is not acceptable to law or judicial scrutiny. Accordingly, WPA 20666 of 2023 is allowed, comma, thereby directing the bank to disburse all due family pension to the petitioner and to go on paying such family pension to the petitioner irrespective of the claims of the bank in respect of alleged dues of the husband of the petitioner regarding family pension loan. Full stop. However, comma, nothing in this order shall preclude the respondent bank from taking appropriate.
Irrespective of possible matter, last time your question as a family pension. Is a family pension.
Irrespective
of the claims of the bank in respect of alleged dues of the husband of the petitioner regarding family pension loan.
Family pension, etc. Full stop. Next para. However, nothing in this order shall preclude the respondent bank from taking due steps in accordance with law for recovery of the amount claimed by the bank in lieu of outstanding dues left by the petitioner's husband. If such proceedings are taken out by the bank, comma, the same will proceed without being prejudiced in any manner by any of the observations made. Not rest of Yes, so what is the matter?
Yeah. is the daughter of a
It's with what about service? Good service has been affected. Petition is the daughter of
daughter of a deceased account. Not only sought for information on the date of the disease and supervised the not lying in the account because she is one of the heirs of the account. That was refused. But still that on the ground that the petitioner is related to the account of the parcel which cannot be disclosed. Against which an appeal was made. And whether therefore whether that appeal was also under the Right to Information Act, that appeal was filed. That was also might not stand down, might not be on the same ground. Whether but the appellate for directed might not to contact the branch and or produce in support of your claim that you are the heir of the original released account. I have my not made the presentation which my not documents and some of the for bank paper turnaround. And in view of such fact, my lord, I am not in a position to make that's why I am
none appears for the respondents despite service affidavit of service filed to be kept on record. The petitioner is the heir of a deceased account holder in respect of the respondent number 1 bank. Next para. When the petitioner approached the bank for information regarding the amount lying in the account for laying claim thereto, the bank refused to furnish such information, upon which an appeal was preferred under the Right to Information Act by the petitioner. The appellate authority directed the bank to consider the petitioner's claim if the petitioner approaches the bank with proper documents regarding her heirship, etc. Next para. However, despite the petitioner having written representations to the bank, nothing has been disclosed by the bank regarding the details of the said account. Next para. If the petitioner is an heir of the account holder, of the deceased account holder, the petitioner definitely has a right to know the pertinent details of the account, in order to enable her to lay claim to the contents of such account. As such, the bank acted divorce its authority in refusing to entertain the representation of the petitioner altogether. Definitely, the petitioner has to satisfy the bank prima facie as to her being the legal heir of the deceased account holder. However, beyond that, the bank does not have any business to refuse information to the petitioner. Accordingly, WPA 20793 of 2023 is disposed of by directing the respondent number 1 bank, by directing respondents to consider the representation of the petitioners as annexed to the petition, and upon giving an opportunity to the petitioner to satisfy the bank that the petitioner is the actually one of the legal heirs of the deceased, to disclose the details of the bank account to enable the petitioner to lay a claim thereto. Next para. The petitioner shall approach the bank with necessary documents to satisfy the bank that she is an heir of the deceased account holder within a fortnight for date for the bank to take the action as directed above. Upon being so satisfied, the bank shall immediately furnish such details to the petitioner. No address to cause.
yes. It's good also might not continue that, but here might not be acting was without any delays.
The second appeal lies.
I am the heir of the disease. Thereafter, I made
Sir,
representation.
Mitra, since you took the path of Right to Information Act, you have to go in second appeal. How can this court intervene?
So far as the present case is concerned, my lord, I have also made representation stating therein that I am the legal heirs and I have furnished documents in support thereof.
Mr. Rai, what is your ground of refusing?
Not, the petitioner here not has submitted a self-declaration that she is a legal heir, but we cannot act on the self-declaration.
Not the certificate also given in support thereof.
What certificate?
Councillor.
Certificate of the council.
No, succession certificate or something like this.
Succession certificate, my lord, I cannot get unless the amount, so far as the amount lying in the account. That has not been disclosed, I cannot take claim.
Yes, Mr. Rai, there is something. Often several banks have an act on, say, they can produce a notarized declaration or even a magisterial declaration. But unless they, how can they obtain a succession? Mr. Mitra is right on that. Unless they get to know the contents.
Here, the problem is the account note is not an orphan. The account is an either a survivor note. But it was a joint account in the name of the father and mother of not the petitioner. The father has died. It is being survived. It is not being operated by the survivor, who is the mother. But if it was an orphan account note, the petitioner's case not, as the lordship said, not, we would have acted. But if it is the survivor not, who is the owner of the account now, not the survivor may be the nominee. But then in that case, not he has a claim against the survivor. The survivor should be not made a party to the respect to this.
I can make a party also, my lord.
I think that will be easier.
Because, my lord, all right, my lord, the survivor is holding the account for the remaining things is here.
No, if it's either or survivor, Mr. Mitra, it's not like usual law of inheritance. The account now belongs to the survivor.
When it finally turned to banks, Reserve Bank circular,
Yes.
it provides my lord benefit of page 25. Benefit the survivor and give a valid discharge to the bank. Payment to confer a valid discharge to the
Page 25.
page 25. Benefit of the survivorship, if the benefit is provided, the survivor can be even though payment to the survivor will confer it valid discharge to the bank. The survivor will hold the money as trustee for the legal heirs unless he is the sole beneficial owner of the balance account of not the sole legal heir. Thus, the survivor's right unless he is the sole owner of the balance account. Sole legal heir of the people is only the nature of the mere right to collect money from the bank. If the legal heirs of the whether if they supply measure so far as the account is concerned, I can take claim because mother has also filed a partition suit against me.
No, Mr. Mitra, then you have to apply before that because as far as the account is concerned, yes, the money lying there, surviving is the receiving hands, she is holding for all the years. But that does not compel the bank because as far as the account is concerned, vis-a-vis the bank, the survivor is now the operator of the account. Why should they disclose it to a third party? You take out an application in the partition suit, Mr. Mitra, you know what to do. You take out an application, you take out an inventory regarding the bank or
inventory, if I can make my lord, there may not be intermediary, I can make. But
Make in the
that
civil
should
suit.
not be disclosed.
No, you have to approach the civil suit.
That the approach already been made by the mother, mother in the civil.
No, in the civil suit you have to apply. You are a defendant there.
I am a defendant.
So you apply for disclosure of that account.
Disclosure of that account.
That must be a part of the schedule.
Must be part of the schedule, but so far as the account number, everything is required to be taken matter from him.
Take your steps in the suit, Mr. If there is a suit pending, have you disclosed the suit, partisan suit?
Yes, matter. Partisan suit is matter.
In the petition you have disclosed.
Disclosed.
All right.
Mother has instituted a partition.
You have stated that.
Yes, bro. Basically,
Very well. I'll give you liberty to approach the civil court for getting an appropriate order, but not here.
So far as the
account is concerned, if I make a interrogation, is such event minor to the event if it does not disclose the other end. Minor is such event minor or minor the fund which are in that. In the event such is not disclosed minor, that that event minor dies.
Order 11 rule 21 is there. Order 11,
21.
Order 11 rule
21.
Yes.
So far as
Hard suit goes.
so far as disclosed and disclosed.
Yes,
But
Mr.
what
You know better than me what to do in the series. Much better than me.
no,
Absolutely. Much before me, before I learned. Learned counsel for the petitioner contends that the petitioner is one of the legal heirs of the deceased account holder with the respondent 1 bank. The petitioner sought for information regarding the account after the demise of her father. However, the bank having refused the same, the petitioner went up in appeal under the Right to Information Act. However, the appeal was also dismissed. It is argued that the petitioner is entitled, as an heir of the deceased account holder, to know the details of the accounts and lay a claim thereto. Next para. Learned counsel appearing for the bank submits that the account was held by the deceased father jointly with his wife, that is the mother of the petitioner, in an either stroke or survivor mode. Next para. As per the banking norms, it is contended that upon the demise of one of the account holders, the account devolves upon the other. Next para. As such, the bank is not duty bound, rather bound by the secrecy of banking norms, not to disclose the details of the account in favor of the petitioner, who was never named in connection with the account in any capacity. Next para. Learned counsel for the petitioner in reply places reliance on the master circular of the Reserve Bank of India with regard to similar cases. It is contended by placing reliance on clause 3 thereof that if the benefit of survivorship is provided, the survivor can give a valid discharge to the bank. It is contended that the survivor is right unless he is the sole owner of the balance in the account, sole legal heir of the deceased, is only in the nature of a mere right to collect the money from the bank. If the legal heirs of the deceased lay a claim to the amount in the bank, they should be advised that in terms of the contract applicable to the account, the survivor is the person entitled to payment by the bank, and that unless the bank is restrained by an order of a competent court, the bank would be within its rights to make the payments to the survivors named in the account. Next para. Thus, it is submitted that the survivor / mother of the petitioner is merely receiving hands, and the petitioner also has a right as heir of her father to lay claim to a portion of the account. Next para. A consideration of the guidelines of the master circular relied on by the petitioner indicates nothing more than the fact that a survivor is merely the receiving hands, subject to the claims of other legal heirs of the original account holder. Next para. However, the bank was within its rights, even in terms of clause 3 of the master circular, to withhold information regarding the account to outsiders. Next para. The bank, as per the said circular, is bound and within its rights to make the payment to the survivors named in the account. In fact, for all practical purposes, it is the survivor who is now entitled to operate the account in exclusion of all others. Next para. However, if the petitioner has a legal right to claim a portion of the property as heir of the account holder, she is well within her rights to approach the civil court where a partition suit is admittedly pending at the behest of her mother with regard to the estate of the deceased father. Next para. Needless to say, comma, under the Code of Civil Procedure, comma, there are several modalities and reliefs given to parties to extract information from the contesting other side in regard to the property which is the subject matter of the suit. Full stop. Be that as it may, comma, such rights pertain to the rights of the petitioner, comma, if any, comma, as a legal layer, comma, subject to being decided by the civil code and do not have any nexus with the duties of the bank vis-a-vis the account holders. Full stop. Hence, comma, insofar as the bank is concerned, comma, it is not duty bound to disclose the details of the account to the petitioner. Full stop. The petitioner may very well approach the civil code for appropriate relief in that regard. Full stop. In such view of the matter, comma, WPA 20797 of 2023 is dismissed on contest without any orders to cost, comma, in the light of the above observations. Audience.
On the other hand, that individually. Item number 1.
Yesterday,
Yes.
on the Eastern Railway, General Manager, it has been received also, and also by Speed Post to Ministry of Now.
Good. Hey, order sheet to the
Questions?
yes.
And the issue which I argued on the last occasion is not practically the same. Same tender is also involved. But you will see page 80. That is the name. Notice inviting tender. Product is mentioned under serial number 2 in the item details. Gas acid all towards the bottom.
Oh, actually, yes.
Then
Serial number 2
serial number 2 item details at page
is item details. Oh, it's main serial number.
yes, page.
Yes.
And then kindly see next page eligibility conditions.
Right.
I am at condition 2, 3, 4 at page 20. Here, I am actually bidding for bulk procurement. I am satisfied also condition number 2. Last matter, it was not bulk procurement. So I am also showing documents to show that I have supplied minimum 20% of the tendered quantity during the last 3 years. Then the same serial number 3 and 4, making India content has to be more than 50% certified by the certificate or the chartered accountant certificate is at page 51.
So you have been rejected on the same ground.
Yes, and the rejection is at page 45. Due to non-fulfillment of eligibility criteria of Himalaya.
Work order has been issued.
No, not yet. The work order is not yet issued.
Since they are not present, I'll stay this tender process further. Senior counsel appearing for the petitioner has made out a strong prima facie case for hearing the writ petition on its merits. Among the eligibility conditions of a tender process in which the petitioner participated, one vital condition was that a particular percentage of the product has to be made in India. Full stop. In support of such component of the tender, the bidder had to produce a certificate by a duly authorized chartered accountant, which the petitioner did in the present case. Full stop. However, due to inadvertence, the certificate of the chartered accountant did not mention the specific product name which the petitioner was offering in the bid. Full stop. The respondent authorities rejected the petitioner's tender on technical ground on the premise that the name of the product was not disclosed in the bid. Full stop. Next para. However, the petitioners are justified in justified prima facie in arguing that since the certificate of the chartered accountant otherwise disclosed clearly that the petitioner's product which was being offered in the bid fulfills the tender criterion, and the other documents produced by the petitioner clearly disclose the product sought to be offered by the petitioner, read in conjunction, there was substantial compliance of the tender clauses. Full stop. Accordingly, the petition shall be listed for hearing on the above issues on January 10, 2024. Full stop. No, January 17, 2024. Full stop. Affidavit in opposition, if any, shall be filed by January 10, 2024. Reply, if any, shall be filed on the next returnable date. The respondents shall remain restrained from issuing any final work order in terms of the impugned tender process till January 31, 2024 or until further order, whichever is
We also mentioned invitation to bulk procurement.
shall remain restrained from issuing any final order only in respect of bulk procurement as contemplated in the said tender.
So that here all direction and
Direction of what, sir? Yes.
So that they can appear.
They'll automatically come.
What your lordship's record, I found out more judgments on the exact point that what constitutes, even if I comply with this condition,
Essential.
but the fact that I have not say written the tender name or tender number, that will not be fair.
Appeals to common sense also. But please those when the matter is taken. He's very hardworking.
Yes. Because I should have not have placed Rashmi Metal. Rashmi Metal, it was not
a bit.
Yes.
Number 2. Yes.
My application.
Yes.
My learning is apprehensive about uploading. I said, some course I do not.
Uploading. I can assure that I'll sign today, by today. I hope it will be uploaded today.
I have given my name to it.
No, they generally, my officers generally remain and upload the same. Unless it's exceptional, some exceptions. They all do.
Yes. Your Worship, I am complaining of the non-action on part of the banking ombudsman.
All have been served. You are for the bank.
For banking ombudsman.
And you are for the bank.
And this for my little friend, just structurally management. If a lordship is sick, it cannot have been filed prior to 12th of October 2023, as I understand, because the application happened on 12th of October 2023.
Yes.
And the complaint which was lodged with the banking ombudsman, that was closed and communicated on 6th of October. There is no mention in the writ petition, and I'm carrying the order that was passed and that.
Please give a copy to him also. Yes. What is your grievance in the writ petition?
Yes, my title deeds were submitted with the bank, and there was a OTS proposal. The stipulations in OTS proposal were complied by my client. Even after that, the title deeds were not fixed. About 67 communications were sent from our end. They failed to act.
No, you approach the ombudsman.
At first, I had approached the bank. The bank did not act. Thereafter, in the month of July 2023, I had approached the ombudsman. And since there was no positive response from the end of the ombudsman, I was forced to.
But before you file from the writ petition, there was something.
This was not given to me.
Take instruction on this, come back on Monday. At the outset, learned counsel appearing for the banking ombudsman hands over a copy of an order by the banking ombudsman dated October 6, 2023. Learned counsel appearing for the banking ombudsman submits that although the writ petition was affirmed and filed on October 12, 2023, prior thereto on October 6, 2023, the complaint of the petitioner had been closed by the ombudsman by the said order, as such, it is contended that the petitioner does not have a cause of action, at least vis-a-vis the ombudsman. Next para, learned counsel for the petitioner is requested to take instruction on such order, a copy of which is handed over in court today, and to the learned advocate for the petitioner, for further orders, the matter be placed in the list on December 18, 2024. December 19. 18 na kore 19.
I'm so grateful to you.
Thank you.
Item number 3.
I'm for the petitioner, my lord, in this item number 3. My lord, may I pray your lordship to come hear the case on Monday, your lordship. Kindly, my lord. I'm outstation.
Online message? Oh, Mr. Dutt, you are appearing, yes.
Yes, my lord, kindly hear this case on Monday, your lordship. I'm praying, your lordship. I'm actually outstation somewhere, my lord. I'm stuck there.
Can't hear you, Mr. Dutt.
My lord, may kindly hear the case on Monday, my lord. Is it possible, my lord?
You're muted. Your photograph is freezing. Where are you?
My lord, I'm audible, my lord.
আসতে করে নেই তো মাইকটা
100 করা
একটা order record করে due to online disruption at the end of the learned advocate for the petitioner, the matter is adjourned for
I'm audible, my lord. My lord, no audible, my lord. My lord, I'm audible, your lordship. Item number 3. Am I audible, my lord? No. Item 3, my lord.
None appears for the petitioner. The CAC Limited is representing to counsel. Let the matter stand adjourned for the.
Item 3, my lord. I'm audible.
Yes.
मेरा वही सुनाई नहीं.
Who is appearing? So you're also there. He's the senior because he's not senior to the court. And start the matter. Yes. Maybe you're senior, you're also on the panel. You must be having instructions. No, I am saying you know. Are you prepared in the matter? Why? Your name should be cancelled from the panel then. You are also on the panel. So why are you appearing for the state if you are not prepared? If you are without the brief? Why should I? Why should I? Why are you on the panel then? If this is the level of assistance, then I feel for the state. Adjourn for the day. No use hearing him. An adjournment is sought by the state. Let the matter stand adjourned for the day.
No, I believe they will not ask for any adjournment for taking instructions.
I don't believe. You may believe. I don't.
So that I can do it.
Number 6.
Yes, Mr. Mishra, you are for? Let him come. You start the matter. You start the matter for the petitioner. Argue their case, then argue your case, then I'll pass my.
Just say what is written in the bill.
You don't let your juniors read the briefs. Keep it to your close to your heart. None of them are prepared in the matter. Why? Because of this matter. Because of the merits of the matter, you said.
But is the applicant service? The issue is with respect to not rectification of the sales certificate.
Mr. Mishra, please take your seat.
Rectification of the sales certificate issued in my favor. Auction notice was made that this flat is on auction. because of your section 13(4) and after that.
You purchase, yes.
Yes, I purchased. After I purchase, that they are only saying that these are rights, not the ownership rights. But when we go and ask them, they say, no, it was there in the auction notice. You should have seen that as is very basis. So the income grants has to be specifically mentioned by the rules. But here, it comes to the same notice once at page 18 of my report.
Yes.
But you also see not this part of this fifth item.
Yes, yes. Manoj Kumar, Anil Kumar. Yes.
All that part and parcel of commercial unit, diamond prestige, such and such. Encumbrance, not known to you, there is a claim of that is the amount to be paid. This was the claim of the we asked for the papers, they did not pay anything. Thereafter, we paid the entire one. The interest consideration was 10 crores, 40 lakhs and 50,000. We paid that. Sales certificate was also being issued, but only with respect to the leasehold rights. The problem is, instead of project, a portion of the landlord retained and gave the leasehold right to the developer. So the developer transferred the leasehold rights and the owner transferred the ownership rights to my vendor from whom I purchased by auction. This was the situation.
Borrower.
Borrower. Now the bank is only not selling the leasehold rights, not the ownership rights for no reason also.
No, the secured asset covered the ownership also.
But I should.
No, I'll come to this.
But I should give ownership to the sale deed once. And it comes to page 27. Is the mother date of the borrower.
Yes.
Diamond paper and enterprise asset. And it comes over. Alcove construction.
This is the parent deed of the borrower. Yes.
Anil Kumar engineering, Manoj and Anil Kumar.
Yes. Yes.
Brother, kindly, you should see page 30. Clause B. The vendor is the owner of the sale premises recent portion. The assignor here is the lessee under the vendor in respect of such. Under the sale leases, it has been agreed the assignor would be entitled to public service. That was the class of the development agreement. Kindly turns over page 31, clause E. The purchaser being desirous of owning such and such second schedule. This is this. Now the vital point. Now this indenture represents that in the premises aforesaid and the consideration of such and such only by the purchaser to the assignor paid at or before execution such and such and acknowledged and in further consideration of a sum of 1 crore to such and such only by the purchaser. So not the total consideration amount by my borrower was made in two parts. One to the assignor, one to the vendor, the landlord. So by this sale deed, both the leasehold right as well as the ownership of the flat had transferred in favor of the borrower. Now, after this was done, this.
No, but it was stated thereafter, after the comma, the assigner doth hereby assign its leasehold interest. And the vendor doth hereby convey transfer ownership, right? Yes.
The entire thing was transferred. Now, after this, the sales certificate comes to page 56.
Yes.
And this year, 8 and 9 of such and such, sold transfer of leasehold rights. Now compares this with the lot.
Page 56, you say?
In the
transfer of leasehold. Oh.
This was never disclosed. in the notice. And why would a person want to purchase a leasehold right of a flat which already the transfer of ownership rights have been also given to the owner, and nobody would not give the other right only for the leasehold right. So this is thereafter not in page 7 I made a representation regarding the correction of the certificate because this was the thing. I'm not reply from the bank is at 65. After 57, you are at 65, 60. My demand notice. 65 is the reply from the. Second paragraph is relevant. Please note that property in question of mortgage with our banks deed number such and such, entering and such mentioned in the letter. Since inception, bank has taken optional property under certificate of leasehold rights. Nowhere not in the public notice, in the auction notice, was there any mention of leasehold? Rather, on the contrary, I indicated to the lordship that in the remarks column,
They say post in all the communications post auction. After the auction, there.
My submission it is not. Because I quote based on not the valuation of not as it were.
We'll continue tomorrow. Yes, we'll continue tomorrow. Not tomorrow, I think, Monday. Although the hearing was commenced, the same cannot be concluded today due to paucity of time. So let the matter stand over till December 18, 2024. Affidavit of certificate kept on.